Okay, you guys, let's go ahead and get started. Good morning. I'm glad to see you all back and ready to roll. Hope you had a fun afternoon and evening reading over family law. I got a few questions by email. So please come at the break and ask me any questions or any concerns you might have over this material. I just usually like to start day 2 talking about test-taking techniques from when I took the bar and having studied the bar a lot, specifically Code 1 and Code 2. That Code 1, I think, is more manageable with regard to time. Code 2, and I know Joe Menges will tell you this, has been much more time sensitive. And so you're going to have to pay attention to what your professors tell you, or your lecturers, I should say, tell you regarding the time pressures associated with each, so you know you can move in and move out of those questions. I have talked to many examiners before about what they see deficient in the bar exam. And in many cases, they think the analysis is deficient. You might know the answer and you might be thinking of it in your head, but obviously the challenge is to be able to write it quickly and efficiently, but analyze it. So it's very important for you not only to memorize this black letter law, but be thinking in your mind, I need to be sure I am talking about the facts of this case, not just what the rule of law is, because while the rule of law might be correct, if you're not using it in the context of the facts in the question, then you're going to either not get credit or only get partial credit, and you need to get every point that you can get. I think it is also important to be sure you are using the absolute term of art and do not paraphrase the law as much as possible. And that is when you're making your little skinny outlines or you're studying, you're making sure you're writing down this specific, the Bergeron test. You're writing down specific terms of art so that when it comes time to write it, you're not like, oh, what does that say? Oh, it says sort of this, because sort of this does not cut it. And making sure, like for Code 2, for example, the answers are usually right and wrong about who takes. And there's not a lot of middle ground, where there might be middle ground on how you interpret things in other tests. And for the family law questions, it's usually right or wrong. So be sure you are answering definitively. If there's any question, I think it's important to start the question, your answer rather, with the answer. The answer is a yes or a no or a maybe, or it depends. Answer the question, then provide the rule of law, then provide the analysis. A lot of times what I'm hearing is they give the correct answer in the rule of law, but not the analysis. So that's important that you provide not only the answer, the rule of law, and the analysis in each question. Now, when you get to Louisiana Code of Civil Procedure, you're doing it in 2-3 sentences because they're quick little questions. And so you're going to have to watch your time and figure out for specific tests how long you have to do things. And really keep your feet to the fire. If you look at the clock and you know you only have 20 minutes to do one question and you're over, move on. Because if you don't finish the question, and they'll give you some points here and there, but if you're writing too much, you need to realize that you need to get in and out of those questions. Doing the old tests is very important, because history repeats itself. Writing a good question is hard. And so once they get a good question, they tend to reuse it, changing the names, maybe changing the question a little bit. But imagine the relief you will feel when you see a question that you absolutely know the answer to. So it's important to spend the time going back to all those old exams and at least outlining the answer and then reading the answer so you feel pretty confident. All right, if you have any questions about that or about studying, I'm happy to answer. I work with a lot of students at Loyola who take the bar, and I've tutored students who didn't pass the bar that are coming from other states and other places as well. So I'd be happy to talk to you in a break about it. Okay, we are in juvenile persons. We're going to do juvenile persons today and all these other persons that I spoke about. We started talking about child custody, the BIOC factors, and we talked about the Bergeron standard for considered decrees and the two-part test for consent decrees. I'm at the top of page 28, And now we're going to talk about custody preferences and how courts in Louisiana award custody. There really is in Louisiana a hierarchy, and the code sets forth essentially 4 custodial arrangements, and you start at the top and you work your way down. The first being in accordance with the agreement of the parents. So Louisiana courts want the parents to agree. That's why a lot of these cases go to mediation, because if you can get an agreement of the parent, the court will award custody in accordance with the agreement of the parents unless it's not in the best interest of the child. So that does require the court to make a determination that the custodial arrangement is in the best interest of the child. Now, because you have 2 opposing parties who are coming into an agreement, usually they're fairly balanced, and so it is in the best interest of the child because they're a check on one another. However, there have been instances where the courts have not given custody in accordance with the agreement. And there are usually issues where it was a small child, every other day they were switching custody, and the court says that's not in the best interest of a small child, and then awarded custody, joint custody in some other fashion, some other physical sharing of time. The second in the hierarchy is parental custody, but I really think you can divide that into 2, and that's joint parental custody and then sole parental custody. And then you'll see the 4th one in the hierarchy is non-parent custody. So it's really agreement of the parents, joint custody, sole custody in the parents, and then non-parent custody. So if the parents can't reach an agreement or the court has determined that the agreement is not in the BIOC, then custody will be awarded to the parents jointly. That's joint custody. It is definitely the majority of all custody orders that are entered are joint custody. Sole custody will come into play if one parent can show by clear and convincing evidence that sole custody in that parent is in the BIOC. A parent does not have to show substantial harm to receive sole custody. They just have to show by that heightened standard of clear and convincing evidence that sole custody in themselves would be in the best interest of the child, which is often hard to do. There is a strong preference for joint custody. You see courts not awarding joint custody when the parents really can't get along, and there can be no cooperation, because joint custody mandates exchanging information, discussing major decisions, and if the parents are unable to do that, you would see a court award sole custody. In order to implement joint custody, there is a document called a Joint Custody Implementation Order. The joint custody implementation order is the document with all of the detail. It contains detail about when the children will get picked up, what school they will go to, medical decisions. Its detail often depends on the parents and what they want to agree to. It is required except for good cause shown. So all joint custody orders should have a joint custody implementation order with it. What does it do? If you look at number 2 and number 3, it allocates physical custody and it allocates responsibility. That allocation of responsibility is what people term legal custody. So while custody is an umbrella term, there is physical custody and there is legal custody. Physical custody is time with the child. Legal custody is decision-making authority over the child. So there's absolutely 2 aspects of custody. The first, of physical custody, the code says, look, we want frequent and continuing contact with both parents. So a joint custody order, a typical one would be every other weekend, custodial time with one parent, and then every Wednesday during the week, or every Wednesday and Thursday during the week, so that both parents are a part of the child's life. Frequent and continuing contact. To the extent feasible, and if it is in the best interest of the child, custody should be shared equally. Now that when that was put into the code, it engendered a little bit of controversy, because does that mean in all cases it should be a 50-50 arrangement? And courts have said no. It's really, once you determine that joint custody is the preferred arrangement, you can look to see if shared physical custody is in the best interest of the child. And if it is, and it is feasible, then equal physical time can be warranted. So not only are we talking physical custody, but the joint custody implementation order has to designate who has legal authority for the child. And that is this designation of the domiciliary parent. People fight over who is the domiciliary parent more vigorously than joint custody because joint custody is almost preferred. Because joint custody is awarded so much, most parties think, and most lawyers will advise, you're not going to get sole custody, but what we can do is get you domiciliary status. What does domiciliary status means? That is the person with whom the child primarily resides. Okay, so it's usually the person that is the primary residential parent, and so will have usually more physical time, but not necessarily. But what the big one is letter B, decision making. The domiciliary parent has authority to make all decisions affecting the child unless the implementation order provides otherwise. Now, that might seem unfair. You might say, wow, that is a big deal, and it is a big deal, and that's why people fight about it. But their decisions on major issues can be challenged in court. But we're not talking about whether the kid should get a new pair of shoes. We're talking about whether the kid can go to Europe for the summer. We're talking about big decisions, where the child should go to school, that those decisions will rest with the domiciliary parent if there is a disagreement. But for a major decision, like where to go to school or whether to go to Europe for the summer, then you could have a court hearing. The domiciliary parent will be presumed, their decision will be presumed to be in the best interest of the child, but it can be challenged by the non-domiciliary parent. If there is no domiciliary parent, then the rules governing parental authority will apply, and we're going to talk about those. And those really say, at least today, and they're under revision right now, that father knows best, that when a dispute arises, that the father's decision will ultimately prevail. You have seen some courts, and if you took family law, I'm sure you talked about this, you are seeing some courts award co-domiciliary status. And that's usually when there is equal physical sharing of time. There is no such thing in the code for co-domiciliary status, but it is happening in practice. That courts, when they order an equal sharing of time, they say you have equal decision-making authority. Okay, obviously that could lead to trouble if the parents do not agree on an issue when there's a co-domiciliary status, but do know that it is happening. You see that joint custody obligates the parents to exchange information and to confer with one another. So while the domiciliary parent definitely has the decision-making authority, they have to confer with the other parent and discuss issues with the other parent because it is a joint custody arrangement. Okay, so that's joint custody. If you think of next is sole custody, really, it's up in that first paragraph, but keep in your mind that sole custody with the clear and convincing standard comes next. And then last in the hierarchy is non-parent custodian. If joint or sole custody to either parent would result in substantial harm to the child, okay, so that's the standard for non-parents. The non-parents are going to have to show substantial harm to the child. Then custody can be awarded to another person that the child has been living with in a wholesome and stable environment, or to any person who can provide that type of environment. Don't be fooled by the singular nature of this language from the code. It doesn't mean that it has to be one person. There are many custody orders that award custody to the grandparents jointly. It's just once you are taking custody away from a parent from a constitutional standpoint, there has to be a high standard that's proven, and in Louisiana, it's substantial harm. Custody of illegitimate children. Over the years, the Supreme Court got involved, and the Louisiana Supreme Court has definitely followed suit, that there really is no distinction between legitimate children, children born during marriage, and illegitimate children, children born outside of marriage. In fact, there was a push that started 10 years ago now to get that word illegitimate out of the code. It started, it never finished. So their illegitimate is still in the code in lots of places, but the idea is I think it would be more appropriate for you to say a child born outside of marriage or a child born of the marriage. And there really is little distinction at this point between those two children. The big distinction you will see is if you have a child born outside of marriage, that's not acknowledged by the parents, and usually it's the father, then that child does not have any filial rights. But once there is some type, and we're going to talk about in the filiation section, there is some type of filial relationship, then they get all rights. Now what I have here is under number 2, the non-legitimated, non-acknowledged children. And you're going to see this when we come to tutorship again. I have it in 2 places because it was the subject of a question that has been asked twice. It's one specific article, and I think it can apply to custody and to tutorship because courts have relied on this for custody determinations. There is no specific code article about custody for children born outside of marriage. If you look at the way the code is set up, custody appears under the or after in the same title as marriage. So some have argued that those custody articles only apply to marriage. Courts are not doing that. They're applying the custody articles to children born outside of marriage. But there is a tutorship article that specifically speaks to who is the tutor when you have a non-acknowledged child and the mother dies. So courts have looked to this for custody as well. They don't have to, but I have it here and you'll see it again for tutorship. And you'll see Article 256 says when the mother is of right the tutor of her child born outside of marriage when the child has not been acknowledged by the father or has been acknowledged but without the mother's concurrence. So at her death, the father, who either acknowledged without her concurrence or who never acknowledged, does not get preference for tutorship. Therefore, he would not likely get preference for custody if he did not acknowledge the child, but rather preference for tutorship goes to the mother's parents or the mother's siblings, her relatives, because there is no acknowledged father or an acknowledged father without her concurrence. And so there is absolutely a distinction between tutorship and between custody, but I bring it up here because this deals specifically with the rights of a child born outside of marriage and has been tested. Okay, so that's custody. BIOC factors, preference, custodial hierarchy, preferences. Next is visitation. Now, visitation applies when there is a parent or relative without custody. This term is still getting misused. It's getting misused in the questions on the bar exam. The examiner will say the court awarded joint custody with mom as the domiciliary parent and dad with reasonable visitation. That is not correct. Y'all don't do that when you start practicing, because if there is joint custody, it's physical time. It's not visitation. Visitation occurs, and the code is very clear, for a parent or a non-parent without custody. So once you have joint custody, it's not joint custody and visitation. I mean, you could have visitation by a grandparent, but the parent in a joint custody circumstance is not going to have visitation time. They're going to have custodial time as a joint custodian. So if you see here first, let's talk about parental visitation. So this is for parents. A parent who is not granted custody or joint custody is entitled. Okay, that's an entitlement. Entitled, and that's what the code uses, to reasonable visitation. So they're entitled to visitation. It must be reasonable unless the court finds after a hearing that visitation would not be in the BIOC. So to deny a parent visitation, you have to have a hearing. You have to have a hearing to deny visitation, and the court must determine that it's not in the BIOC for that parent to visit. Otherwise, they're entitled to it. Next is grandparent visitation. Grandparent visitation, the article was amended recently, so I would make sure you know this. And grandparents, there was an amendment passed that allows a grandparent who is not granted custody to get reasonable visitation if it's in the BIOC. Okay, grandparents used to have to show some type of extraordinary circumstance, like the death of the parent, the interdiction of the parent, or some other type of long-term relationship with the child in order to get visitation. Because grandparents are such a part of a child's life, this was passed in order to give grandparents an easier path to get visitation of a child. If you remember the Troxel versus Granville case, United States Supreme Court case that talked about the fundamental right of parents to the care, custody, and control of a child, There is a concern that grandparent visitation could step on those constitutional rights. And so most state statutes had some sort of restriction on the visitation. Louisiana did for a period of time, but most recently this statute expanded the rights of grandparents to visitation. So I think it is potentially a question that might be asked. That now they just need to show not only reasonable visitation, but that it's in the BIOC. The other part of that article, interestingly enough, says that the court must hold a contradictory hearing to determine whether to appoint an attorney for the child. Okay, not a contradictory hearing to determine whether it's in the BIOC, which they would have to do ultimately to allow it, but a contradictory hearing to determine whether to appoint the attorney for the child. And I think that would happen if there was a request for visitation and it was opposed. Then the court will hold that hearing, would likely appoint an attorney for the child in that case to determine what is in the best interest of the child, always taking into account the constitutional right of the parents to oppose and possibly prevent visitation. Okay, third are other relatives. These are other relatives who are not grandparents, because now there's a specific rule for grandparents. And you'll see here for the other relatives, you're showing extraordinary circumstances. Under extraordinary circumstance, any other relative by blood or affinity or former step-parent or step-grandparents may be granted reasonable visitation if it's in the BIOC. Now, what is extraordinary circumstances? We know that extraordinary circumstances can include when a parent is addicted to a controlled substance. But beyond that, the case law is pretty scant on this. There was a trustee of a trust who was a fourth cousin of the child, who was the only relationship to the settlor of the trust, who wanted to get visitation of the child, and the court said that was not extraordinary circumstances. Even though he was the only relative on that side of the family alive, it was a fourth cousin, and the court said no in that instance. So there's really not a lot out there about what is extraordinary circumstances, but what is clear is that the court has to consider factors to determine ultimately if they find this extraordinary circumstance, then they have to consider whether it's in the BIOC. The factors are listed for you here: the prior relationship between the child and that relative, the need for guidance, the preference, and then importantly, the cooperation with the parents. This relative needs to cooperate with the parents because that's an important, again, constitutionally protected right. And then the health of the child and the relative. I don't know that you need to memorize these factors like you do the BIOC factors. These are fairly obvious. You could talk about them. You talk about any fact you would see if you got a visitation question in the fact scenario that would go to the BIOC. There is a specific statute that talks about visitation rights for grandparents and for siblings. And what's interesting is when the law was changed to expand the rights of grandparents to visitation, they did not change these statutes. What these statutes were intended to do was to give extraordinary circumstances in certain circumstances. And you'll see here if the parent is deceased, interdicted, or incarcerated. In those instances, what this article says, or statute says, is that the siblings and the grandparents of the child can get visitation if it's in the BIOC. So that means that they don't have to prove extraordinary circumstances. The death, the interdiction, or the incarceration is the extraordinary circumstance. Well, now, obviously now, grandparents don't even need this because grandparents don't have to show extraordinary circumstance. But these statutes would still apply to siblings. So these statutes would still apply to siblings, but I think they've been rendered moot for grandparents because now grandparents don't have to show extraordinary circumstances. All they have to show is the BIOC. You can see as well, if the parents of a minor child have lived apart for 6 months, then in extraordinary circumstances, grandparents and siblings can get visitation. Again, I think this is moot for grandparents because of that change in the law, but could still apply to siblings. There is a specific code article about the denial of visitation if the natural parent whose felony rape resulted in the conception of the child, or for any family member whose intentional criminal conduct resulted in the death of a parent of a child. They will be denied visitation by law. There are a few issues that I want to bring up for custody and visitation. And the first is that courts are not to grant ex parte interim custody unless immediate and irreparable injury is present. The order can only last 30 to 45 days, and the other parent must be given visitation. You're going to see this come up in the bar exam. This has been tested on a few occasions about temporary custody orders. How does dad get temporary custody of the child? And you can do so through an ex parte order, but you have to show this immediate and irreparable injury. And what practitioners will tell you is you're usually using this article when you're seeking sole custody, because there is immediate and irreparable injury and something's going on with the child and you want custody of the child because you're concerned about injury to the child. It can only last for a limited time. You're going to have to show, and you'll see this more in the answer and in your Code of Civil Procedure outline as well, you're going to have to show that it would be futile to attempt to contact the opposing party, or that it would be detrimental to the child, but then the order can only last a short period of time, and then you'll have a contradictory hearing. Custody hearings can be closed to the public, and obviously the court can appoint attorneys for the child. Custody evaluations have been tested. The court may order the evaluation of a party or of the child for good cause shown. You're going to hear today me use that standard a lot, for good cause shown. When you get to the bar and you forget a standard, that's a pretty darn good guess. Good cause shown is all over the code, and this is one of those places that to get a mental evaluation, you're going to have to show good cause shown. The evaluator can be selected by the court or the parties, and the evaluator serves as a witness for the court. Okay, even if one party chooses an evaluator, that evaluator can be cross-examined by both parties because the evaluator becomes a witness for the court. The court can order parties to mediate their differences because, remember, we're trying to get to an agreement of the parents. And then there are no suspensive appeals in custody. Once custody is ordered, that's what happens with the child. If it gets reversed, then custody changes upon the reversal of that judgment. It's not suspended during the appeal. Compliance with custody and visitation orders, this is relatively new. It was passed in 2008. It hasn't been tested, but there was this problem because parties were getting joint custody and not exercising their custodial time, or were getting visitation and were not, the other parent was not permitting them to exercise the visitation. So these articles were added in order to give remedy for the parent who is either keeping the child because one parent is not exercising their time, or refusing to release the child to the other parent. Unless good cause is shown, the parties must abide by the custody and visitation orders. That should seem pretty obvious. A contempt action can be brought if a parent fails to exercise visitation or fails to allow visitation or custody. In either of those cases, you can put the other parent in contempt, and ultimately the prevailing party can get costs, and can actually get costs associated with a babysitter. You know, if the parent didn't come pick up the child, and so they had to keep the child. There's an expansive amount of damages in these cases that are very fact-specific, so that one parent is not shouldering the burden, or if one parent is not getting their time, then they can get additional time and get costs for having to sue about it. Moving the residence of the child. Moving the residence of the child, the relocation statute, has not been tested. But it underwent another revision. I think this statute has undergone at least 5 revisions since I've been teaching. And this is used a lot in practice. There are parties, and it's a difficult statute because imagine if you had a child and you lived in Baton Rouge and your ex-spouse moves with the child to New Orleans. It's not that far, but can you really make the soccer games in the afternoon? Can you really make the school play in the middle of the day? It becomes more difficult. So when does a parent have to notify you and potentially have a hearing about whether they can relocate the child. And so that's why I think Louisiana law has gone back and forth, because people have different thoughts on this. And so now the relocation statute is clear, but it has changed. So be careful if you learned prior law, if you're looking at some old outline that has prior law on it. What is the definition of relocation? It means a change in the principal residence of a child for a period of 60 days or more. And of course, it's not temporary. People leave, evacuate temporarily because of the storm, and that's not going to be seen to be a legal relocation to then have to rely on the relocation statute. So when does it apply? Very simply, it applies when the child will be located out of state. And that means even if you're in Lake Charles and you go right over to Beaumont, that's out of state, period. Once you move from New Orleans to Bay St. Louis, out-of-state relocation statute applies. If it's not an out-of-state move, but an in-state move, if the child is relocated 75 miles from that child's principal residence, if there is a custody order, which is most cases, there's a custody order, or if there is no principal residence or the parents have equal physical custody from the domicile of the objecting parent, the party who has the right to object, and usually that's the other parent. I would suspect if you get this question, you're going to get a simple two parents. One parent wants to move, and there is another parent that has custody of the child, and they're going to have the ability to object. This statute is really like a due process type of statute. You're going to get notice of the relocation, and then you're going to get the opportunity to be heard. Who must give notice? If you look at this list here, it's really almost all custodians, sole custodian, domiciliary parents, equal physical custody of the child. What's not included, maybe this is a better way to remember it, what's not included is a non-domiciliary parent. Okay, so like the non-domiciliary parent, if there's not an equal physical custody relationship, or just a parent with visitation. Those parents don't have to give notice if they're going to move, because think about it, it's not really like a relocation of the child, because that's not a primary custodian of the child. Notice has to be made to any person recognized as a parent and any person awarded custody or visitation. So keep in mind that if grandparents are awarded visitation, they also get notice. Whoever has visitation will get notice. Whoever has custody will get notice. You do it by mail, register, certified, return receipt requested, 60 days before the move. 60 days before the move, or within 10 days after knowing of the move if you're within that 60-day period. Because some people find out they have to move 30 days before they actually have to move. So then you get 10 days. Except for a person with equal physical custody. So kind of leave them out for a second. Then the parent who receives notice must object within 30 days after receipt of that notice. So they actually have to do something affirmatively. If they do not object affirmatively, then the relocating parent can move. They're going to have to go and file an objection, have a hearing to determine whether relocation is permitted. But for a parent with equal physical custody, the rules change. You see that under E. The parents with equal physical custody don't have to object. The person seeking to relocate either has to get court authorization to relocate or has to obtain the consent of the other parent. So, and this is because they're sharing equal time with the child. And this should make sense. That person is either going to have to consent or we're going to have a contradictory hearing about relocation. But otherwise, there has to be an affirmative step by the party who received notice. For parties with visitation, they cannot object to the move. They can only come in and ask for a relook at that visitation schedule and get that visitation amended. So the grandparent can't object to mom moving, but can say, I need a new visitation schedule because I'd like to continue visitation, and the move is not going to permit it at this time. If you do not give notice of relocation, it can be used against you, obviously. Return of the child. It can be caused to make the relocating parent pay expenses incurred, and it can actually result in a modification of custody. Okay, so that's the relocation. I could see that coming up in a multiple choice question with some of those little specific rules about when it applies or how long you have to give notice and when you have to object. So I would make sure you know those. There's a specific act, the Military Parent and Child Custody Protection Act. This is new, was passed in 2010. And this is really to help military members who go on deployment. What was happening is that military members would go on deployment. The other parent says that this is a material change of circumstance, which it is. The court would modify custody, and then the circumstances would change in the child's life because of the modification of custody. The deployed parent would come back and would have to seek a change of custody again in order to get their same custodial rights put back into place. And sometimes they wouldn't even win because there had been a change in the child's lifestyle during the time period of deployment. So an act was passed to say that, look, when you go on deployment, the custody order cannot change, but it can be temporarily altered. And actually, some of the time that went to the deploying parent can go to the deploying parent's relatives, so that there's still a connection with the relatives of the deployed parent. And then also, when deployment is over, that temporary order goes away, the prior order gets reinstated, so they don't have to relitigate it, and then you can't even make changes to the prior order for 90 days. Let everybody settle back into the parent being home, and then if there has been a material change of circumstance, then a party can move for a modification. But the deployed parent does not have to worry immediately upon coming home that there'll be a new custody order. Jurisdiction in child custody matters. This was asked for the first time in 2008, and it was a very simple question, and I would not expect them to get very detailed on this. I also think this is a good question for multiple choice. The UCCJEA is the Uniform Child Custody Jurisdiction and Enforcement Act. It has been enacted by 49 states in little different form in some of the states, but it's a really great statute that you will know is the basis, the issue of the question, if you see parties moving with children between different states. Okay, so this applies on cross-border type of disputes. And so that will clue you in right away that the UCCJEA would apply. What the UCCJEA does, and again, 49 states have it, it says which state is the appropriate state to make an initial custody order over the child. And then after you figure an initial custody order, any modifications of that order follow a specific rule. The modification of the order was the basis of the question, but I think it's important to know that initially they could ask you what state is the appropriate state to assume jurisdiction over the custody dispute of this child. And so what you would say is the primary test that the court will consider is what is the child's home state. Which state is the child's home state? Home state is defined in the statute as the state in which the child lived with a parent for at least 6 consecutive months before the filing of the proceeding. So you're looking for 6 months before that petition for custody was filed. What is the home state of the child? That's the state that should have jurisdiction. It can also be the state that was the child's home state within the past 6 months, but now the child is absent from that state and a parent still lives in the state. The perfect example of that, and this, if you practice family law, you need to be sure you understand this one. Mom and dad live in Louisiana. Mom and dad are getting divorced. Mom is going to move back to Texas to live closer to her family. They have a child. She takes the child with her. For the first 6 months that mom is gone, because dad remained in Louisiana, Louisiana is the child's home state. That's what that provision means. So, from a practicing standpoint, you need to advise the client to file the petition for custody within those first 6 months. Because if not, and she files in Texas, Texas is going to rightfully assume jurisdiction, because then Texas will become the home state of that child. Okay, so it can be if the child is absent, but for the first 6 months, Louisiana would remain the child's home state, and it would be appropriate to file here. And then the last one is really a post-Katrina if the child is absent for a period of time because of an emergency. So let's say there is no home state. When would there not be a home state? When the child is under 6 months old, or if the child's been moved around a lot. Okay, and they've moved back and forth from Louisiana to Texas for periods of time, or they moved from Mississippi to Louisiana to Texas, then in that case a different test applies. Then Louisiana can exercise jurisdiction if the child and at least one parent have a significant connection. The term of art there is significant connection with the state, and substantial evidence is available. Substantial evidence is the word you want to use there too. Is available concerning the child's care, protection, training, and personal relationships. This is referred to as the substantial evidence significant connection test. So when you don't have a home state or the home state has declined jurisdiction, then you go, it's a hierarchy, you go to number 2, which is significant connection, substantial evidence. And that's what you're analyzing. I think those would be the only 2 that would come up on the bar exam, but ultimately Louisiana can also get jurisdiction if other states decline or by default, because no state is assuming jurisdiction. So now we have a state that made an initial custody determination, and this was the basis of the question. You have a state that made an initial custody determination. That state, let's say it's Louisiana, has exclusive continuing jurisdiction. That's the term that you need to use. Exclusive continuing jurisdiction until either state court determines that no one lives in the state that would otherwise have exclusive continuing jurisdiction, or the issuing state court determines that there is no longer any connection. Substantial evidence, significant connection here. So the example is Louisiana has the initial custody order. Okay, they were the home state of the child, and now mom has relocated to Texas. Mom has been there for 3 years. She wants to modify custody. Can she file that modification of custody in Texas? The answer to that question is no. Louisiana maintains exclusive continuing jurisdiction unless Louisiana or Texas determines that no one lives in Louisiana. And let's say dad is still here. Okay? Or Louisiana would have to determine, because Louisiana is the issuing state, Louisiana would have to determine there is no significant connection or substantial evidence here. And if dad is still exercising visitation and the child is still coming to Louisiana, the court's not going to relinquish jurisdiction in favor of Texas. And that same result happens no matter what state you're in, because everyone has that same rule, the 49 states that have adopted it. To modify another state's order, it's really just the reverse. Louisiana has to have initial jurisdiction under the rules, and then it has to be determined that the other state court no longer has continuing exclusive jurisdiction. Courts can decline to exercise jurisdiction if it is an inconvenient forum or if a party seeking the jurisdiction has engaged in unjustifiable conduct. That would be like secreting the child, bringing the child to the state in an attempt to get jurisdiction. The court can simply decline because of the actions of the parent. And then temporary emergency jurisdiction. This allows you to get immediate temporary custody orders, but it can only happen if the child has been abandoned or it's necessary to protect the child from abuse, threatened or actual abuse. So what happens is you actually have the child present with you. Let's say Texas has the initial custody order, child has been living with Texas, child is 16 years old, calls dad on the phone who still lives in Louisiana and says, mom left with her boyfriend. She told me to stay in school, that they were going to look for work out west, and she'd be back in a few months. And so dad says, what's going on? Dad goes and picks up the kid, drives to Houston, picks up the kid, brings the kid back here, but Texas is going to be where he has to litigate it. So he's thinking, this doesn't make sense. I've got to go litigate it in Texas, get a custody order so I can get my kid brought back here because mom left for a few months? No. He comes to Louisiana, he's got the kid in the courtroom, and he's going to file a petition for temporary custody. Using this provision of the UCCJEA, he's going to say this child has been abandoned, and I need temporary custody. He will win, and the court's going to say, go argue for your modification in custody in Texas, because Texas has jurisdiction over this case. But I'm going to give you temporary custody to keep this kid safe for this period of time, is how it works. Okay, so that is child custody. BIOC factors, hierarchy, other relocation statute, other specific issues in custody, but what's been tested is will Sally get custody of the children? Joe wants to modify the custody arrangement. How is this custody arrangement classified, and what will Joe have to show in order to modify it? That's what has been coming up routinely. So make sure you feel very comfortable with that, and make sure you use the facts to make some analysis if you get that BIOC question. Okay, I'm just going to start child support for the next 5 minutes so we stay on target. Child support has been tested 5 times in the last 24 exams, and the good news is that I do not think there'd be any chance you will have to calculate child support. It is very difficult to test, and so I don't think you have to worry about that worksheet and how you fill that thing out for purposes of the bar exam. What the examiner has been doing when testing child support is testing the duration of the child support, how long it can last, and has asked these general questions. Will Sally be able to get support for the child from Joe? Sometimes there's a filiation question in there too. Well, Joe is going to have to, Sally's going to first have to establish that Joe is the biological father by filing suit, yada, yada, yada. Then Joe will be responsible for child support. In other cases, I think what they're asking is a general, yes, because Joe is the biological father, he is going to have to pay child support. Louisiana follows the income shares model, and here's how it works generally. So I think you need to have a general understanding how our child support guidelines work, but I'm not going to spend a lot of time going through a worksheet and explaining how you would fill it out, because I can't imagine you get that. Child support can be interim or final, and it's based on the needs of the child and the ability of the parents to provide support. So that is like your umbrella. It's always based on the needs of the child and the ability of the parents to provide support in accordance with Louisiana child support guidelines. We have a statute that spells out exactly how much it supposedly costs to feed, clothe, and shelter a child, and then you get some additions. The duration gets tested, and child support in Louisiana is paid until the child reaches the age of majority, which again is age 18 or fully emancipated. We're going to talk about emancipation. Always consider, if you're emancipating a child, that at that point there will no longer be any child support due if the child is emancipated. Child support can continue in limited circumstances past the age of 18. And the first is it can extend to the age of 19 or the child's high school graduation. So what happened when the age of majority changed and was reduced from 21 to 18? Every state started dealing with this problem. The age of majority was reduced, and then all these kids were not getting support to finish high school. And so kids were dropping out of high school because a parent couldn't afford to continue to pay for them. And so every state has dealt with this differently. So if you go anywhere else, be sure you check the statute. Louisiana says if the child is unmarried, dependent on the parents, and has not graduated from high school, this would not count for college or any other type of education, but for high school, and they're still a full-time student in good standing, you can get child support until they graduate from high school or until they reach the age of 19. So you better get out of high school by the age of 19, or it's going to stop no matter what. For the developmentally disabled child, as long as the child is a full-time student in a secondary school, that can extend to the age of 22. So know those two specific rules. There is no age limit for this, and this is under number 3, the alimony to be paid as a child. You're going to see more articles on this a little later on, but ultimately it's not deemed child support per se, but it's deemed an alimentary support obligation that parents always owe to their child. The child can be 50 years old, and if the child is 50 years old and can't get enough governmental benefits in order to meet their needs, and needs are really food, clothing, shelter, then the parents can be obligated to support the child. Child support will terminate depending on whether the award was made per child or whether it is an in globo award. So for a per child award, the child support will automatically terminate when that child reaches majority or 19 or 22, whatever age would apply in that specific case, but it's automatic when it's just child support order for Sally Smith. Okay, most child support orders, if it's more than one kid, are in globo awards, which means it's for Sally, Joe, and Trey, and it's $3,500 a month. And so in that instance, when it's an in globo award, it does not terminate until the youngest child reaches the age of majority. And you think, damn, what about those people who have a 12-year-old or a 15-year-old and then a 2-year-old? You mean they got to keep paying that child support until the 2-year-old reaches the age? The answer is technically yes, but what happens is they go to court and they say this is a material change of circumstance. I used to say, and you'll definitely win material change of circumstance, because that seems patently unfair to me that you wouldn't. And I can tell you there is more than one case out there where the court has denied the material change of circumstance if the kids were close in age. And they did not reduce child support if a child aged out. So I don't want you to think it's definite. You got the 16-year-old and the 2-year-old, you have a good case that your child support's going to go down. But if they're close in age, it's not automatic. It will be when the youngest child reaches the age of majority. Okay, we're going to take our 10-minute break now, and we're going to come back and talk about the amount. Okay, so we are talking about child support, and we talked about the duration of child support, and now we're going to talk about the amount. Like I said, there are lots of fights over this, but it would be very difficult to test. The examiner has asked twice, can Mary receive child support from Joe? What factors would the court consider in making a child support determination? And so you would start with child support is awarded based on the needs of the child and the ability of the parents to pay, relying on the Louisiana Child Support Guidelines. And then you could, after we talk about this, give a general summary about how the Louisiana Child Support Guidelines work. Louisiana uses the income shares model. The income shares model is the model used by the majority of states, and it is a model based on the share of the total household income each parent earns. They will pay child support in the same share. If it's a 60-40 split, dad makes 60% of the total household income, mom makes 40, he will ultimately pay 60%, she will pay or assume 40% is what the income shares model means. So obviously one of the most important considerations under this model is income, and each party's income has to be calculated first. It means actual income or potential income if this parent is voluntarily unemployed or underemployed. So voluntary unemployment or underemployment will allow the court to impute income, but, and I mentioned this yesterday, if a parent is caring for a child under the age of 5, income is not imputed to that parent. Courts can consider expense sharing with a new spouse, but in a very limited circumstance. The situation is mom and dad get divorced, mom gets remarried, she marries wealthy guy is supporting her so she doesn't have to work at all. Does that mean in the child support guideline her income is attributed as 0? Well, no, not necessarily, because her expenses are being paid through someone else's income. Can you use that income? And the answer is yes, but you'll see in number 2, if it directly reduces the cost of a party's actual expenses. So it has to directly reduce the expenses. This is really a question of proof. Oftentimes, if the parties are both working and they're sharing income, the party whose child support is at issue will say, my income covers my expenses and that's it. Even if they're living large, they'll say my only actual expenses are X, Y, and Z, and my income covers that, so you can't impute any of my spouse's income. It's just very hard to prove. So ultimately, any pre-existing child support or spousal support obligation is subtracted from income and then it's combined. Okay, and this is how you get this income share. Then each party's income is calculated as a percentage of the whole income, and that will be used later to apply to the child support dollars that will be owed. So once you get to this combined adjusted gross income, then you go to this chart. If you've ever seen this chart, it's several pages that deals with monthly income from $600 a month to $30,000 a month. And then it has 1, 2, 3, up to 6 kids. And you just find your monthly income, and then you go to the number of kids, and it gives you a number. And that's the basic child support obligation. That's intended to cover food, clothing, and shelter for the child or children. You have to interpolate in between the guidelines if you don't make the exact number on the chart. And then if you are off the chart, exceed $30,000 a month, then the court can use its discretion, but it has to be an amount above the highest number on the chart. That would seem pretty obvious. And then the court is permitted to place a portion of any amount awarded in a spendthrift trust used for the education or medical needs of that child. This is for high income earners. Okay, this is used for, in Louisiana, some professional athletes. So professional athletes, high income earners, because if you think about it, they make some of them $100,000 a month, and you don't need all of the money to care for the child, even though the child lives a really, great life. Some of that money can be put into a spendthrift trust. You'll learn about what that is when you get to Code 2. That can be used at a later point. So I think that could come up in Code 2 as well. If you're below the chart, the minimum amount of child support that can be awarded in Louisiana is $100. $100 a month. And Louisiana, as an FYI, is not on the lowest end of that. Lots of states have $50, some states have $25. So, but the minimum in Louisiana is $100. So now you have this basic amount, right? This comes off of the chart. Well, this is food, clothing, shelter. So now there are some add-ons. And the add-ons are listed here in number 5. Health insurance, child care costs, extraordinary medicals, other extraordinary expenses. All of those get added. So what typically gets added, obviously health insurance, if there are net child care costs. And then for the other expenses, it's private school tuition gets included there oftentimes, and costs of camps and other extracurricular type of activities or summer activities, and in some cases transportation expenses. Those are the ones you typically see. So now you have basic child support plus additions. You get to this final child support number. This is a monthly number that it would cost to raise these children. That's what you apply your percentage to, that you figured out based on the party's income. There is a rebuttable presumption that the guideline amount is correct. The court can deviate from the guidelines if it is either inequitable to the parties or not in the best interest of the child. So if you think about it, the court's likely going to deviate up if it's not in the best interest of the child, or deviate down if it's inequitable to the parties. Because we need the parties to be able to live on their own as well, and so if the amount is too high, the court will deviate down. So now, let's say it's a 60-40 split. Dad owes 60% of that number, mom owes 40% of that number. Well, they don't both pay that amount. It is the non-domiciliary parent who pays the domiciliary parent his or her share. So if mom was the domiciliary parent, dad will pay that 60%, whatever that is, to mom for the benefit of the child. Mom doesn't write a check for 40%, she just pays the bills. And she buys the clothes. And she gets that 60% from dad for child support. The parent owes the other parent his or her share as a money judgment. Okay? There can be direct ordered payments, like you pay the private school, you pay for the health insurance, but for any non-direct payments, it's a money judgment. The reason that that is important is because if you need to modify it, you need to go to court to modify child support. Because if not, and this has happened, they think there's an agreement, 3 years go by, dad's not paying the full amount, mom gets a lawyer who says you can sue for all that past due child support. There's a judgment that says you owe $500 a month, you paid $200 a month. You're going to get all that back child support due and owing plus interest and penalties. There is an adjustment for a joint custody arrangement. That was noteworthy for a long period of time. It came out of a case. It's now in the revised statutes. And what this is intended to capture is a parent who has joint custody, not the domiciliary parent, but has the child physically for a considerable amount of time. The idea was a parent said, look, if I have the kid for 30 or 40% of the year, then I shouldn't have to pay this amount in child support to the other parent because I'm having a lot of expenses going on here. Yet I'm paying for something when the child is not there. So the law reacted and said, okay, in a very certain circumstance, there can be adjustment if you have a joint custody circumstance. And here's when it applies. It only applies in rare cases when the parent has physical custody of the child for more than 73 days. 73 days is 20% of the year. This is referred to sometimes as the 20% rule. Once you get over 20% or 73 days, then the non-domiciliary parent has to show that they have an increased financial burden, which they usually can, right? The kid's here all the time, I have to have a room, I have to have a wardrobe, I have to have the fridge stocked all the time, I have an increased financial burden. They not only have to show an increased financial burden, but that the domiciliary parent has a decreased financial burden. That's the hard part of the test to prove. The decreased financial burden, mom's saying, I still have to have a room, I still have to have a wardrobe full of clothes, I still have to have food here. So that's often the rub about proving these type of cases, but it definitely is available. Miscellaneous child support issues. The retroactivity of the award says, look, if it takes a long time for a court to hear your request for child support, the award will be retroactive to the date that you asked for it. The legal term is used retroactive to the date of judicial demand. Okay, so child support orders are retroactive to the date of judicial demand unless good cause is shown not to do so. And that only happens if it's been a year and there's been continuances due to the parties. They might not order it that far back. How do you enforce child support orders? You use contempt proceedings. Again, you make past due payments executory. You can get attorney's fees and costs. We talked about that in the terms of spousal support. Remember that one provision that says you can get attorney's fees and costs. It applies to child support. You can get the payer parent put in jail, but that is not preferred for obvious reasons. They're not going to be paying in jail. And then the prescriptive period on getting past due is 10 years. Remember, spousal support is 5 years. Prescribes in 10 years, but each payment is interruption of prescription. You can also revoke a delinquent spouse's licenses. And we're talking about driver's license, license to practice law, medical licenses, hunting licenses, fishing licenses. All those can be revoked if you're not paying your child support. You can also get bank balances from banks. And you know that income tax refund that people look forward to at the beginning of the year? If you're not paying your child support, you can now intercept those income tax refunds, and it goes to the custodial parent. Modification of child support, you'll see the same test. It's the material change of circumstance. This has been tested. Material change of circumstance between the time of the award and the time of the motion to modify. So something has changed between the original award and the request for modification. Louisiana mandates income assignment orders. So remember, that's when the employer, the Texaco, is paying the domiciliary parent directly. But if the parties agree to the contrary in writing or the court finds good cause, it won't do so. So while it's mandatory, it's not really mandatory. It doesn't happen in a lot of cases. There's one specific provision if the payor does not believe that the parent is using the money for a child. I had a student once that told me that her ex hated her so much because he was convinced she was sitting at home eating bonbons, getting her nails done and her hair done. She said his hand would shake every time he wrote that check to me for child support because he was convinced I was not using the money for the child. Well, what could he do? He can request an accounting if the court finds good cause. So he'd have to say, look, my kid does not have a coat for winter. And I'm giving X dollars a month that should allow mom to buy a coat for the child. I want an accounting to see what she's spending the money on. Okay, but you're going to have to prove, again, that standard of good cause. Child support must be paid until the judgment is terminated by court order or by express or implied agreement between the parties. I say that with the one sort of practice point. If you do any of this work, get a court order, because while parties might think they have an agreement, parties change their minds and now say we never agreed to that. And if you don't have anything in writing and you don't have any court order, you're going to be stuck with past due child support. Okay, so that's child support. Very limited questions coming out of child support. Be ready for a general type of question that you could most certainly answer, talking about the income shares model generally, and obviously termination duration of the award. Okay, the big topic, which I think is probably the most challenging in this outline, is biological filiation. This is the one, it's tested in Code 1, it's tested in Code 2, it's tested almost every single bar exam in one way or another. So I want to be sure you know this. To me, it is the fascinating question. It's the who's your daddy question. And we could come up with about a bazillion hypos on biological filiation. I could spend days talking about this. I'm going to try to focus on the big points, the points that they have hit. And frankly, you guys, this is one you've got to take on your own. Sit down, write it out, figure it out, and memorize it. There are so many different time frames that are being tested again and again that it's clear to me that the examiners think that those graduating don't know it yet. And so they're going to keep asking until they feel like there's a really solid understanding of this. So what is filiation? Filiation is establishing some type of link between a parent and a child. It's either done biologically or through presumptions, and that's what we're going to talk about, biological filiation, or by adoption. If you don't have a biological link or some type of presumption, you can always adopt a child, and then they're filiated to you, just filiated through adoption. So we're going to talk about biological filiation first. The first is proof of maternity. There used to be no mention of maternity because you can usually tell who is the mother of the child. But there are great legal issues that could come up under maternity. And that is, and I will tell you this is a hot topic because if you heard about it, there was a new surrogacy bill that was passed by both houses of the Louisiana legislature and was vetoed by Governor Jindal. A portion of the bill, my understanding, was being raised again, and there was new support for it. And so surrogacy has come up, and so surrogacy gives the proof of maternity question. Because if you think about a surrogate relationship, a woman carries a baby for another couple, who's considered the mother of the child? Well, if you look at number 1 here, maternity is established of proof that the child was born of a particular woman. Proof is by a preponderance of the evidence, but it's birth, not DNA. So that would mean the surrogate, the one who gave birth to the child, would be considered to be the mother of the child, even if there was an agreement with another couple, and even if the gametes were used from the other couple, that the birth mother is considered the mother with one specific exception. And that exception is listed under number 4. Louisiana has one specific exception for a husband and a wife. This only applies for a married couple, okay? It's a husband and a wife who provide a sperm and the egg, so both of their gametes, for in vitro fertilization into a surrogate who was related by blood or marriage to either of them. If the surrogate is related by blood or marriage to either of them and carries the child using their gametes, the married couple's gametes, then the married couple's name will go on the birth certificate as the biological parents of that child. Okay, so that's the one exception that Louisiana has recognized this surrogacy relationship. Otherwise, Louisiana has a law that says surrogacy contracts are unenforceable. Compensated surrogacy arrangements are unenforceable. And they're not criminal. In some states they're criminal, but they're not enforceable. So that's why Louisiana's law on maternity makes sense. They would say, look, we don't like surrogacy arrangements, therefore the mother who gives birth to the child is considered the mother. So keep that in mind. Now, where all of the issues thus far have come up are proof of paternity. Who is the father of the child? You see this first little paragraph under proof of paternity. The way I organize it in my mind is there's 5 ways, and they're listed here. Presumption of paternity of the husband, presumption of paternity by marriage and acknowledgement, formal acknowledgement, child's action, dad's action. And so that's how I've organized this outline. I'm going to go through each one of these, and I would encourage you to understand each one so that when you get a question, you're thinking in your head, does this presumption apply? Does this presumption apply? Can there be a formal acknowledgement? Can there be an action by the child or an action by the parent? And then you will have covered them all in your head to come up with the right answer. So let's talk about the presumption of paternity of the husband. This has existed in Louisiana law and in every state for many, many years because the law favors legitimacy of a child. The husband of the mother is presumed to be the father of the child born during the marriage or within 300 days from the termination of the marriage. That's intended to capture conception. Okay, so it's really the husband of the mother is presumed to be the father of the child born or conceived during marriage. Conceived under Louisiana law is if the kid is born 300 days after termination. How does termination usually come up? Death or divorce. Okay, if the father dies, then the child is born within 300 days, it's still considered to be a child of that father. Or if they get divorced, the child is still considered to be a child of the prior husband after the divorce if the child is born within 300 days. Now, this is a very strong presumption. We're going to talk about the two ways to overcome it in just a minute, but recognize that this strong presumption can be overcome with a disavowal action by dad or a contestation action by mom. Okay, there's one more presumption that kind of occurs under the presumption of the paternity of the husband, and that is when there's really almost competing presumptions. Think of this Jerry Springer event. Mom is married, she gets pregnant. Okay, she's pregnant, she gets divorced. She gets divorced from husband one. The very next week, she gets married to husband two. She gets married to husband two and then has the baby 2 months later. That baby is born during her second marriage. So you say, I know, second husband's considered the child. But that child is born within 300 days of termination of her first marriage. So you go, who's the father? Well, I know who the daddy is. Because if she married the second man that quick, that second man's probably the daddy. But the law says exactly the opposite. So that's why you will remember this. Because it's absurd. The law says when you have those competing presumptions, you have to have two marriages. First marriage ends, and then second marriage begins. The child is born after the second marriage, but within 300 days of termination of the first. Then first husband is considered the father. Y'all are going to love this. The Louisiana Law Institute recommends the obvious, that it's the second husband. The legislature says, but that would be writing adultery into the code. And we cannot do that. And so they said no, and now the first husband is presumed to be the father of the child. He will likely disavow. If he doesn't, mom can file a contestation action, because I know of a few cases where dad said to mom and didn't do anything, so mom had to realign paternity because he didn't want to help at all because he was so angry. And so the first husband, remember that, is considered the father of the child. He has the right to disavow the child. And if he disavows the child, look at number 2 here. If the first husband or his successor disavows, the second husband is presumed to be the father. So immediately upon that judgment of disavow by first husband, it attaches to the second husband. Full out Jerry Springer, the second husband can disavow if the third person is the father of that child. The second husband or his successor can disavow, and you see, a 1-year preemptive period from the day the judgment of disavowal by the first husband is final and definitive. And the reason that the second husband knows about this is because the procedure rules say when the first husband disavows, he is an indispensable party. He's got to be given notice of that suit. So second husband knows if this disavowal is granted, I'm going to be on the hook. And so then the second husband can determine, or his successor can determine, to disavow as well, which is available. Know that time period. So these presumptions are in place. We have to have a way to overcome them. The first is through the disavowal action. The disavowal action will be used only when the man and the mother were married. I cannot tell you on my exams how many times I have students say when the parties aren't married, girlfriend comes up to boyfriend and says, the dude's not on the birth certificate, and says, "You're the father of my child. What should the man do?" I get a lot of people say disavow the child. There's no such thing because there's no presumption to disavow. He's not the father. What do you tell him to do? You tell him to do nothing. Sit on his hands. Say whatever he wants to her. But he doesn't have to do anything. She has to establish the filial link. These presumptions establish a filial link. So when you have a marriage, that's when man would have to disavow because he has a presumption and he might not be the biological dad. So then he's going to file his petition to disavow, and he's going to have to show by clear and convincing evidence that he is not the father. His testimony alone will not be enough to meet that standard. Today, it's easy to get DNA tests, blood and tissue samplings. That's usually what's used to prove that you are not the father. Some people have proved physical impossibility that they were not in the country at the time of conception, and the court has not required DNA evidence. Okay, so you can use other type of evidence as well. It is not difficult to prove that you are not the father if you're not the father, but know the clear and convincing standard. What is difficult are the time limits. Very important, these time limits. Put stars by here. When does the presumed father have to file? He must file the suit within 1 year after he learned or should have learned of the birth. Circle birth, put stars by birth. It's a prescriptive period, but it's within 1 year of actual or constructive knowledge of birth. So, mom and dad are married. He believes he has a blissfully, happy marriage. The child comes out, does not look like him. He's concerned, but he doesn't want to mess things up because, all babies sort of look alike. And so he thinks, maybe that is my kid, and he doesn't do anything. If he doesn't do anything for 1 year and 1 day, he has forever lost the right to disavow that child. So many people want to say, and these cases exist out there, dad finds out when his kid is 8 years old that his wife had an affair and his kid is not his because his kid needs medical attention and dad's blood type does not match. He finds out in the hospital the kid is not his. He's 8 years old. He's livid. What happens? He says, I need to disavow the child. This is 1 year from the date I learned I wasn't the father. That's not the test. The test is 1 year from the birth of the child. This protects the child. It stinks for the party who was duped. There's no doubt about it. But it's a very clear law that favors the legitimacy of the child. This child believed this was their father for 8 years, and Louisiana says, that's it. That child, that person, even though not biological, will be still considered the father of that child. There is only one exception to this 1 year birth rule, and that is if the mother and the husband continuously lived separate and apart for the 300 days preceding the birth of the child. Okay, so that means he couldn't, very unlikely, have conceived the child with her. For the 300 days they were living continuously separate and apart, then he gets 1 year from being notified in writing that a party in interest has asserted that he is the father. How does that usually come? That usually comes because they get sued for child support. But it could come in a letter of, hey, this is yours, showing up at the front door. And it could become a notification, it has to be in writing, that a party in interest has asserted that he is the father. Well, how would I expect this to come up? This would come up if the parties, and this happens sometimes in the bar exam, the parties separate but they don't divorce. And people do this all the time. The parties separate, go live separate lives, but never file the papers. If mom moves on and gets pregnant by another man, the presumption attaches to her husband because he's still her husband. He can disavow that child, but he's now going to get 1 year from the date he's notified in writing that she says he's dad. And usually that's because now she wants to seek child support. And then he will be able to disavow the child. These time limits apply to the heirs of the husband. This has come up in Code 2 on more than one occasion. And if you think about it, why is this coming up? Because now you have heirs to the husband who are going to have to share their inheritance. And they say, I'm going to have to share with this baby? That is not my father's child. We need to file the disavowal action so we don't have to share some of our inheritance with this child. Can they do so? The short answer is yes, but they are governed by strict time constraints too. If prescription began to run and the husband dies before it's accrued, they get a little bit more time. The successor who would be adversely affected gets 1 year from the death of the husband in order to disavow. But if prescription had not begun to run, then the successor who is adversely affected gets 1 year from a notification in writing that someone is asserting that he is the father, that their relative is the father of the child. So just make sure you commit that to memory. The importance of this time limit is extreme. If the time limit passes, the presumption is irrebuttable, even if another man is proven to be the biological father. That tells you that Louisiana is seriously unique, and this absolutely comes up in that Louisiana recognizes dual paternity. You can have two fathers. There are many cases where child support is received from both fathers, the biological father and the legal father. Because if you're the legal father and there is later a biological father who's proven, both of them are considered to be the fathers. Child can inherit from both. Okay, exception to the right to disavow. You cannot disavow a child born as a result of assisted conception to which you consented. Case came up recently about this. Couple couldn't get pregnant. Husband says, I consent to use, his sperm was the problem. I consent to using a sperm donor to have a child. He would be able to disavow the child otherwise because it's not his kid. He'd be able to prove he wasn't the father of the child. But because he consented to artificial insemination, he cannot disavow that child. So that's dad's right to disavow. Mom also has a right. Mom's right is called the contestation and establishment action. They have tried to test this once. I do not think they were successful, but I think that that's what they were asking for. But the right did not exist under the facts as they gave them to you. But it was clear to me, and you'll see it in one of the answers, that that's what they were getting at. They wanted to talk about mom has this right, but the time periods have already passed. Or mom has this right, but she's not married to the second guy, and so you can't use it because there are pretty strict requirements. So here we go. Mom can sue to establish two things, and this is the contest part. Former husband is not the father, and then the established part. Present husband is the father. This tells you that she had to be married to the first and married to the second. If she wasn't married to the first and married to the second, this does not apply. She could not use this. So it strictly applies former husband is not the father, and that her present husband is the father only if the present husband has acknowledged the child by authentic act or by signing the birth certificate. How would this come up? This comes up where mom and the second husband know that the child is his, but the first husband is presumed under that rule to be the father of the child. The case I was telling you about, Dad said, I will sign no document. I will file no suit to help you. So mom had to file the contestation for first husband, established for second husband, and then it realigns paternity. It's actually one of the few instances that terminates the rights of one and establishes the rights of the other. Letter D is very important because, again, the proof, if it's accurate, is going to be easy. But the time limit is an issue. Mom has to file suit within 180 days of her marriage to the second guy and within 2 years of the birth of the child. So, once the child is 2 years old, the right of action evaporates. This is a preemptive period, and so just keep in mind, if the kid is 7 years old and they're asking if mom can file the contestation and establishment action, the answer is always going to be no, because it's past the child's 2-year-old birthday. So it only happens in very limited circumstances. 2 marriages, 180 days of the second marriage, and within 2 years of the birth of the child. All right, that's the contestation and establishment action. So now we've covered the first presumption. Presumption of paternity of the husband can be rebutted by the disavowal action, can be rebutted by the contestation and establishment action. The second presumption also involves a marriage, but it's a subsequent marriage. Okay, this is the presumption by subsequent marriage and acknowledgement. How does this come up? This comes up because girlfriend and boyfriend get pregnant together, and they don't want to get married. So they say, well, let's raise the baby, see how this goes, and see if we should get married. Father of the child acknowledges the child, puts his name, agrees to have his name put on the birth certificate, but doesn't marry mother. Once he marries mother and acknowledges the child, then the presumption attaches, which all filial rights will ultimately flow. So if you see here, a man who marries the mother is presumed to be the father of the child if he acknowledges the child by authentic act or signs the birth certificate. The child must not be filiated to another man, and the mother must concur in the form of a juridical act. So, second husband can't marry the mother and sign an authentic act if there was a first husband that's presumed to be the father of the child, because the child is already filiated to another man. Okay, this has to be when the child is not filiated to another man. And I think it could happen if the first husband disavows the child, then biological father marries and acknowledges the child, and the presumption attaches. Now, you can overcome this presumption through a disavowal action, but you have a very short period of time because now you've made the decision to marry the mother. You weren't married at the time of the birth of the child, and acknowledge the child. So if you see the disavowal action here, the time limit, 180 days preemptive period from the date of the marriage or the acknowledgement, whichever is later. So the last thing that you do, if you already acknowledge the child and then you marry the mother, you get 180 days to change your mind and disavow the child. Or if you married mom and then you acknowledge the child, you get 180 days to disavow. Now, to disavow, you have to prove you're not the father by clear and convincing evidence. The same rule applies for that, but this is because girlfriend says, I swear you're the father, I swear you're the father, I swear you're the father. My dad's going to kill me if you don't marry me. And so child is born, man marries, and then realizes he's not actually the father. He only gets 6 months to realize it, but he can disavow within that 6-month time period. Obviously, the presumption does not apply if the child is filiated to another man. If the child is filiated to another man, we're going to talk about it in a second, and this is the biological father who wants to have rights to the child, an action exists for the father to file suit. He can file an avowal action to establish his rights, but he can't simply marry the mother and acknowledge the child if the child is already filiated to another man. All right, so that's the second presumption. A disavowal action would be associated with that, not the contestation and establishment. The third presumption is raised by a formal acknowledgement. This is dad wants to be involved with the child but does not want to marry mom. So now we're talking about no marriages. Okay? Now we're talking about no marriages. Dad now wants to take responsibility, does not want to marry the mother. So he can acknowledge the child as long as the child is not filiated to another man by an authentic act or the birth certificate. From a practical standpoint, it's signing an authentic act. There's really not signing the birth certificate. You could be at the hospital and are you the father? Yes. And if mom's not married, they'll put you on the birth certificate, but you're not even really signing it anymore. And so usually they're signing an authentic act of acknowledgement. Creates a presumption that the man who acknowledges the child is the father. And once the father formally acknowledges, the child does not need to file any type of paternity action. One of the major distinctions about this formal acknowledgement, especially under prior law, was that a formal acknowledgement favors the child only. Okay, and what does that mean? That means for purposes of the child is fully filiated to dad. Child can inherit from dad, child can file a wrongful death action if dad dies. All rights flow to the child, but all rights do not flow to the father. What does the father get? That's under B. The father gets to have to pay child support, and he gets custody and visitation. That's all rights he gets from the acknowledgement. He cannot inherit from the child. This has come up in Code 2. He cannot file the wrongful death action. The acknowledgement does not give him full filial rights. What does he have to do? He has to file a lawsuit. He has to file the avowal action for full filial rights in order to flow. Now you see letter C. I think letter C is just really, these next two, letter C and number 3, are just really interesting questions. I think it would be unfair if they asked you about this because it is very unsettled. I've talked to the Office of Vital Statistics. They don't know how to answer this question. But we have an old Supreme Court case that says if you are not the biological father of a child and you sign an act of acknowledgement, it's absolutely null because you can't acknowledge something that is factually false. Okay, so like a man just can't acknowledge that he's the father of my child. I mean, he could sign an acknowledgement, but it's absolutely null because he's not. Okay, and that's what the Succession of Robinson case said. And that's listed under number C. So then you say, okay, that all makes sense. It will be considered to be null. Number 3 talks about revoking an acknowledgement. So imagine, man signs an acknowledgement acknowledging he's the father. It can be revoked without cause within 60 days of signing the act. You can go to court and do it. You can submit a sworn affidavit for no reason. You can just revoke it. If you're the biological father, mom's going to have to sue you to prove it. And you can revoke that authentic act of acknowledgement. Thereafter, it can only be revoked for 2 years, is what the law says. 2 years, you have to go to court and prove by clear and convincing evidence that the act was induced by fraud, duress, mistake, or that you're not the biological father. So here's the rub, right? So what happens if you file that action after the passage of 2 years? The law says you only have 2 years to revoke it. Does succession of Robinson still control to say, if you're not the biological father, you're never the biological father? Or does the 2-year limitation mean you can't get out of your acknowledgement and the kid can still inherit from you and get child support from you? It's a good question that no one knows the answer to. The only court case I know involved an acknowledgement and a marriage. Kid was 14 years old. Man says, I am not the biological father of this child. And actually, he admits he knew he wasn't when he signed the acknowledgement. He says, I want to revoke it. I'm not paying child support anymore. The trial court, unpublished opinion, rejected it and said, no, you can't revoke it because you married mom. Even if you're not the biological father, the presumption attached, it's irrebuttable. What we don't know is if there's no marriage and there's simply an acknowledgement. What would happen in that case? Okay. Signing the baptismal registry is not an acknowledgement. It used to be, so if they throw that in, I want you to know that red flag, that's not enough. And then informal acknowledgement. Informal acknowledgement is treating the kid as your own. Okay, this absolutely happens. Girlfriend and boyfriend have a baby together. She gives birth. He's not around at the time. She doesn't put his name on the birth certificate. She actually doesn't want him to be involved in the kid's life much at all. But he shows up. He ends up being a good dad. He calls the kid his own. The whole community knows the kid is his. Calls him son. Comes to the parent-teacher conferences. All that good stuff. But there's never been any filial relationship established. That child is not affiliated to that man. Cannot inherit from that man until there is a lawsuit filed establishing it, which child will be able to do. But that's just informal acknowledgement and is not enough for all the rights to flow between parent and child. There are 2 actions left, and these are judicial actions. Keep in mind, so far, the presumptions have attached because of the marriage, or the presumption attached because an authentic act was signed. The last 2, the child's action and dad's action, are going to court. And the first is the child's action to establish paternity. This is used when dad is not stepping up. And so now, child is going to file suit. From a procedural standpoint, you know it's not actually the child because they do not have procedural capacity. It is the tutor of the child, and usually that's the parent. Mom would be filing the suit on behalf of the child to establish who the father is. Even if the child is presumed to be the child of another man, okay, so that would be legal dad, the child can file suit against biological father. This would absolutely result in dual paternity. The burden of proof is different if the parent is alive or if the parent is dead. If the parent is alive, it's a lower burden of preponderance of the evidence, but once the parent is dead, it's a higher burden of clear and convincing evidence. They're testing those. The time limits are very important, and this has come up on Code 2. For succession purposes, the child has to file the action within 1 year of the death of the father. But it doesn't matter what the age of the child is. The child could be 50 years old, knew this was his dad, no actual filial link was ever established. Dad, who's 80 years old, dies without a will and a whole bunch of money. Child, who's 50 years old, can file a suit. They're going to have to prove by clear and convincing evidence that the man is the father. As long as they do that within 1 year of the death of dad, if they are successful in proving they're the child, they will be able to inherit. For all other purposes, there is no time limit. Your time limit will be governed by the time limit of the law. Like the wrongful death claim, you're going to have to It has to be filed within 1 year of the death, so it's the same. But Social Security, there are different time limits associated with a claim, but nothing would prevent you, if prescription has run, if prescription has been told for any reason, to continue to establish your paternity. Evidence would include informal acknowledgement, cohabitation, blood tests. There is a specific statute that says if the results of the blood and tissue sampling indicate by 99.9% that the alleged father is the father, there is a presumption. And you don't actually have to do anything. The presumption would have to be rebutted. You would just put that blood and tissue sampling into evidence. There is one specific statute about the filiation of a child who is conceived after the death of a parent. These rules, the child's actions, will talk about a child that can establish a filial link. Well, what about a child that was actually conceived after the death of the parent? Okay, this has come up in Code 2. They asked this specific question about this specific statute. It's a very interesting statute. It is in other states, so we're not unique on this. But a child who is born after the death of the sperm donor, okay, so we're talking about post-mortem conception, not just post-mortem birth, but post-mortem conception. Man, the way this comes up, man has cancer and he's going to have to go through treatments that might render him infertile. So he freezes his sperm so that if he makes it through these treatments, a child can be conceived by his wife. And so ultimately he does not survive the treatment and the wife still wants to have a baby with the frozen sperm. If she has the baby with the frozen sperm, and you'll see what's required, if he authorizes in writing that she can use the gametes and the child is born within 3 years of the donor's death, then the child is considered to be a child of that predeceased parent. So the succession will be held open for those 3-year period if there is frozen sperm there. This was intended to apply to frozen eggs as well. Eggs are definitely being frozen now, but the procedure is not being used as much as sperm donation, so we haven't seen it used yet for egg donation, but according to the drafters of this article, it's intended to apply both ways. Okay, let me just finish with this last action and then we'll take our break. The last action is the father's action to establish paternity. It's called the avowal action. Be sure you call it the avowal action. This is the father suing to establish his rights to the child. The perfect example of this is Brad and Angelina, right? They never got married. They had a bunch of children. He's clearly the father. If he's listed on the birth certificate and all of this happens in Louisiana, he doesn't have full rights to the child. That acknowledgement benefits the child only, but not him. So in order to have full filial rights to the child, he has to file a lawsuit. And he's going to have to prove that he is the father of the child, which he'd be able to do easily. Nobody would even oppose it. But he's going to have some type of judgment of avowal establishing his paternity. The standard of proof is a preponderance of the evidence. There is not two different standards of proofs like the child action. The article only says preponderance of the evidence. So even if the child is dead, it's a preponderance of the evidence. It's different. If dad is dead for the child's action, it's clear and convincing. Keep in mind that it's different here. Again, not really going to be a question of proof. It's going to be a question of time limits. Look at these time limitations. This has been tested on multiple occasions. If the child is presumed the child of another man, then the action has to be filed within 1 year from the birth of the child. The scenario where this comes up is mom and husband are married. Mom has an affair. Mom gets pregnant through the affair, and the child is born. She doesn't tell husband. They raise the child. He believes he is the father of the child, but now you have biological father. Biological father has 1 year from the birth of the child to file his suit to disavow. The 1 year time period is short because from a policy standpoint, legislators thought this is very disruptive. And so we don't want to disrupt this child's life when they believe that the husband of the mother is the father, when there is another man who's actually the biological father. So they have to act quickly. There is one exception that's listed under number 1 here. If the mom, in bad faith, deceives the father regarding his paternity, then he must file his action within 1 year from the date he knew or should have known of his paternity, or within 10 years from the birth of the child, whichever occurs first. So again, this means when the child turns 10, the right evaporates. He can no longer avow if the child is over 10 years old. And this is the situation. Mom has the affair and she swears to the man she's having the affair with, you are not the father. She knows he is, but she swears, you are not the father. He will get a longer period of time, 1 year from when he learned or until the child turns 10 years old. And in any event, the action has to be filed within 1 year of the death of the child. Has to be filed within 1 year of the death of the child. If the child is not presumed to be the child of another man, then this can be filed at any time. That's Brad and Angelina. Brad and Angelina, having children out of wedlock, if he's not going to marry mom and he wants more than the rights established by formal acknowledgement, he can file this suit to avow unfortunately, if one of his kids predeceased him and there was money with that child, he could file the action after the death of the child without any problem. The problem is when the child is filiated to another man. These time periods are very strict. If the mom, there is one presumption that exists for child support. I can't imagine you get tested on this, but no, if mom says this is dad, he's given notice and he doesn't respond, for child support purposes, he's considered the father. That really allows the department, the agency that collects child support, a simpler way to collect child support. He might not be the father, but for child support purposes, they can then sue for it if he got notice and he refused to respond. All right, that's biological filiation. I've gone to 5 minutes to. We're going to take a break until 5 minutes after and come on back. He wouldn't have done that. A hobo was not like that. Is it better? Mm-hmm. Thank goodness there's a woman watching. I mean, seriously, I'd have been like, oh. You would have been able to stare at it the whole time. Would have been the problem. I mean, you know, I understand. Yeah. All right, you guys. Okay, we just finished filiation biologically. Filiation by adoption is going to be quick. You're probably sitting thinking, how's she going to finish this in 1 hour? I'm about to skip some stuff for the most part because it never gets tested and it's super easy. And what I usually do, if this is okay, unless I hear strenuous objection, is I go until I finish. And so it might be 1 hour and 5 minutes, but I don't think you want to take a 15-minute break to come back for 10 minutes. So I'm just going to go and finish this thing, and I do move quickly through some of it because it's never been tested. It's super easy. I want you to at least read it because, of course, you do take risks on this exam, and something could come up. And so I'll give you the basics about it and tell you how I would imagine it's going to come up, if at all. Okay, biological filiation, you guys know that cold. Spend time writing it out, making sure you understand how it's organized. Filiation by adoption really is simple because, and they're trying to get child adoptions put into the bar exam, but they have not been successful as of yet. So you cannot get a question about a child adoption in Code 1, so I don't even cover it. What you could get a question about that has come up is the adult adoption. And so the adult adoption had the rules, the adult adoption has come up, and the general rule about adoption has also come up, more specifically in Code 2. And that's really this number 2, effects of adoption. This applies to adults and children and has come up in Code 2. Remember, the adoptive person is the child of the adoptive parents for all purposes. They go in the family tree when you draw your family tree like they were born there. I would always put a sentence in your answer that says something like, Greg was adopted, but adopted children inherit just as a child born of the marriage. So that they know you know that rule, because that could be worth some points. After an adoption, most legal rights between the adoptive person and the biological parents end. There are 2 exceptions. The first one is very obvious. If it's a step parent who adopts, then the relationship between the blood parent stays intact, and it's just the change between the step parent that gets instituted. The one that might not be as intuitive is under number 2. The adoptive person can inherit not only from adoptive parents, but also from natural parents and relatives. Okay, so there was a question in Code 2. The child had been given up for adoption by the mom. The mom died, and then the grandfather died. So the question was, could the child given up for adoption represent the predeceased mother in grandfather succession? And the answer is yes. Okay, even though given up for adoption, the child can still inherit through the biological mother, even to other relatives, not just the mother, but to the grandfather in that particular question. Adult adoptions have been tested once, and the adult adoption rules are very simple. You can think of them in 2 ways. One where there is no judicial authorization needed, and one when judicial authorization is needed. You do not have to go to court for an adult step-parent adoption. When the person adopting the adult child is the spouse or the surviving spouse of the parent of the person to be adopted, then all that needs to happen is the parties are going to sign an authentic act of adoption. It's an adult adoption because the child being adopted is over the age of 18. Okay, I might have kind of stepped over that, but that's what an adult adoption is. The person being adopted is over the age of 18. In non-step parent adult adoptions, you're going to have to go to court. The person to be adopted and the person adopting have to file a joint petition, and then the court will authorize the adoption if it's in the best interest of both parties. If any party to the adoption is married, their spouse has to concur in the adoption. It's a concurrence. It's not an adoption necessarily, but it is a concurrence. That's of the person adopting and the person to be adopted. If not, it will be null. So they're going to have to just sign this, I concur, in the authentic act of adoption. The adult adoption will be effective when it is filed for registry, and you cannot adopt your spouse for purposes of inheritance reasons. Crazy town case where a man tries to adopt his spouse to inherit. This was also a forced heirship issue, so that his wife would be a forced heir to his father because they didn't get along. And the court rejected that for obvious reasons. So you can't use an adoption in an attempt to create some type of inheritance rights. So that's really adult adoptions. Know the step-parent, know the non-step-parent, and the difference between judicial authorization and simply an authentic act of adoption. The next section, the rights and responsibilities of children and their parents. This is referred to as parental authority because someone always needs to be in charge of a child. Okay, they're a minor. There's either going to be parental authority when the parents are married, or it's going to be tutorship if the parents aren't married or the parents are divorced. And we're going to talk about tutorship in a second. This section has never been tested. This section is odd because it's perfect in the code, because remember, the code tells the story and gives rights and duties and obligations, but there's no litigation about the rights and obligations really, because children can't sue their parents. And so while there might be rights and duties and certainly relationships between parent and children, we've not seen any questions come from the bar, so I'm going to go through this very quickly. Children remain under authority until emancipation or majority. Emancipation will cut off all rights. What is the child obligated to do? Honor and respect, obey, and stay home. We know that doesn't always happen. What are the rights of parents? They have the right to have custody, to discipline their children in a reasonable manner, and to delegate authority and appoint tutors. The only thing I could even imagine coming up is under number 3 here. There is something that's used in practice a lot called the provisional custody by mandate. The provisional custody by mandate allows parents or grandparents with custody to give custody to a major, a third person, natural person, for a short period of time, up to 1 year. Parents use this when they go out of the country for 6 months, so that someone's in charge of the child. It can be used to register the child for school if they're not going to be there, that someone has actual authority. It can only last for a period of up to 1 year. Parents also have the right to administer the child's estate. We still have some old law in the books that the father is the administrator of the minor's property, and only if he is incompetent or absent can mom step in. Obviously, question about whether that's even constitutional. In order to administer the property, if you're going to sell the minor's property, you have to go to court. It will end at majority, emancipation, or divorce. Parents also enjoy a usufruct over the child's property. Remember, you heard of the usufruct, the usus and the fructus, the ability to use and enjoy the fruits. They can't sell the property, but they can enjoy a usufruct. The usufruct is non-alienable and non-lienable, but they can use the kid's property, okay? Where they can't use the child's property is if it's a result of the child's own labor. Child star, child's in commercials. Parents don't get a usufruct over that money. They don't get a usufruct over inheritance, or they do get a usufruct over inheritance unless it's expressly excluded. Okay, so the child inherits from Great Aunt Sue, they'll get the usufruct unless Great Aunt Sue says they don't. That doesn't usually happen. For donation inter vivos to the child, they don't get the usufruct over it unless it's expressly included. Because if Great Aunt Sue wants to give the kid the car, then it's for the kid, it's not for the parents. They can't use the car. All sounds great, but again, what happens if they use the car that Great Aunt Sue gave to the kid? Nothing, because the kid can't sue the parents. Now, when the kid reaches the age of majority, if there was damage, they've got 4 years to sue the parents, but they can't do it during minority. Okay, that was the rights of the parents. What about the obligations? Parents get all these rights. Well, they then have obligations to maintain, support, and educate their children, protect kids, and assume vicarious liability. You will hear about this in torts because parents are vicariously liable for the acts of their minor children, whether they want to be or not. Children have no right to sue their parents prior to emancipation or majority. The reciprocal alimentary obligation of parents and children is the interesting concept that I brought up when I talked about child support. This scope of this obligation is as between parents and children, and it's reciprocal, which means that you could be responsible for your parents, and your parents could be responsible for you. It's a limited right of basic food, clothing, shelter, and health care, and you must prove that the needy person is unable to get these resources through other means, and that's usually governmental means. The only instances where you see this law being used are for disabled children over the age of 22. Because remember, you can get child support for a disabled child until the age of 22, but after that, child support ends. So what happens is, if the child is getting any type of governmental benefits and it's still not enough for the child to live, then the other parent usually sues the non-custodial parent to get money under this alimentary obligation. It has absolutely happened where children have been required to pay for a parent who has become homeless. There's actually instances where you can be made to bring the parent into your home. It's under the law, it's very unusual, but it exists. The section on illegitimate children, all this says is that the alimentary obligation between parents and children also exists for children born outside of marriage, only if they've been filially linked to the parent. Okay, you can't have a child born outside of marriage that has no biological filiation to a parent that then comes and sues for this alimentary obligation. They're going to have to prove up their filial link in order to be able to receive money. So I cannot imagine any question coming out of that. It's very rarely used. The cases are very, very old. And certainly for illegitimates, I'm not sure any of that law is constitutional. And it's going to come out of the code very soon. What has been asked and what has come up 4 of the last 24 exams, and I would expect these last 4 topics to continue to come up more in multiple choice questions, but there have been full essay questions about tutorship. There's never been a full essay question about emancipation. There has been a full essay question about interdiction, and there has been an essay question about absent persons. But these are really good questions for multiple choice because they're very discrete, single topics. They don't come up all that often, but they're certainly valuable and come up in practice. So I'm going to talk about tutorship first. Tutorship, in my opinion, is almost better grouped with parental authority because parental authority are the parent's rights over the child during marriage. Tutorship is after the marriage ends through death or divorce, or if the parents were never married. It's the regime of tutorship. The regime of parental authority and the regime of tutorship are the control over the child, and they look almost exactly the same. You have certain rights and obligations over the child, and the tutorship rules provide those rights and obligations just like the parental authority rules. When is tutorship necessary? When one or both parents are deceased, when they are divorced, and you can also add when they are unmarried. Because if they're unmarried, tutorship also comes into play too. Types of tutorship. There are currently 4 types of tutorship. The essay question that was asked about tutorship asked you to compare the different types of tutorship and identify what this relationship, what type of tutorship it was. And so you need to make sure you know the 4 types. Certain situations will be obvious under what tutorship they fall, and then they asked more specific questions about notice rights. So let's talk about the 4 of them. The first is tutorship by nature, and that's for parents. Parents are the natural tutors of their children. Upon the death of one parent, the other parent automatically becomes the child's tutor. Nothing has to happen. Automatically, the parent is their natural tutor with full rights as the tutor. If, rather than death, the parents get divorced, the tutor is the parent with custody. If there is joint custody, then it is considered to be co-tutorship. For an illegitimate child, a child born outside of marriage, you've seen this article already. I brought it up in terms of custody. This came up in one of the tutorship questions, this specific article about the illegitimate child, that the mother is of right the tutor of the child if the father did not acknowledge the child or acknowledge the child without the mother's concurrence. And upon her death, the natural tutor does not immediately go to the father. Okay, first preference is given to her parents and her siblings, secondarily to the father, and clearly at this point the father would have had to have acknowledged the child. Or if he acknowledged her without the concurrence, then secondarily it could look to the father, always awarding tutorship in the best interest of the child. Tutorship is unique because tutorship technically involves both the care of the child and the property of the minor. And so care of the child we all think of as custody. But tutorship is care of the person of the minor and care of the property of the minor. So that's why this is a confusing area of law. And as an FYI, there's a bill that's going to redo all of this next summer. So when you start practicing and you get an issue, the tutorship and the parental authority articles are going to be completely revised. Hopefully your examiner knows this and is not going to ask you any questions about this, because it's not going to be good law for very long. And the law is going to clear up this problem with custody and tutorship about who has custody of the minor and who has control over the property of the minor. That's why this is a little bit confusing. So that's natural tutorship. That's the parent of the child. Automatically becomes the natural tutor upon the death of the other parent. Tutorship by will is the second type. The right of appointing a tutor by will, okay, this should be pretty obvious, belongs exclusively to the spouse dying last. However, if the spouse is an interdict and the other spouse is the curator has the right to appoint the tutor by will. Now, I say tutorship by will, and this can obviously be given in a testament, but it can also be given in an authentic act. So while we call it tutorship by will, it could be given in a valid testament, but if you had an authentic act that was not a valid testament, it could still name a tutor by will. In my will, I name a tutor over my minor children. And so lots of people do this in wills. If I died, the tutor that I name in my will is not going to be appointed as tutor because my husband is still alive. Natural tutorship is going to take place, and he, as of right, will become the tutor of my child. If we die together in an accident, then the tutor by will be appointed. We actually have the same one, so it wouldn't be an issue. But it belongs, the will right belongs to the spouse dying last. So if I died, it would go to my husband. When my husband dies, whatever he writes in his will is who will be named the tutor if he named a tutor for the kids in his will. So that's what tutorship by will is about. The named tutor in the will is not required to accept tutorship, but oftentimes you leave in your will legacies to the named tutor for the benefit of the children. So if they decline to be the tutor of the kids, they can't get the legacies that were left to them because they were tutor. So now think about the issue about divorced parents and the right to name a tutor. That's under number 3. The spouse with sole custody has the sole right to appoint the tutor. So the parent with visitation only does not have a right to appoint the tutor. But for parents with joint custody, you go back to the default rule that the spouse dying last has the right to appoint the tutor. But there is a special rule that allows the parent who died first to appoint a separate tutor over the property of the child. You should be able to remember this because imagine, mom and dad get divorced. They have a child. Mom and dad do not get along at all. Okay, dad remarries, maybe mom remarries. When mom dies, tutorship goes to dad, right? Because he will be the natural tutor. But what if mom has a lot of property that she's leaving to the child? She doesn't want dad to have administrative rights over the property that she's leaving to the child because she knows he can use it. She knows he might use some of it not appropriately. So she can name a tutor only over the property of the child that she leaves to the child. And so it could be a trust that she leaves to the child. She would name a trustee in that case who might also be the tutor over the property in case some property comes out of that trust for the minor, so that dad has control over the tutorship of the person of the minor and of any other property the child owns, but not tutorship over the property in a divorce situation. Several tutors can be named in a will, and you just kind of go down the list. So that's the second type of tutorship, tutorship by will. The third type is tutorship by the effect of law. So let's say the parents don't have a will. They die, and there is no named tutor by will. Or let's say they name a tutor in the will, but the tutor predeceased them. Or the tutor is now an interdict, so the tutor named in the will can't serve as the tutor. Then the court gets to choose from the child's qualified direct ascendants, that's up the line, ascendants, the child's qualified collaterals by blood within the third degree. Remember, collaterals by blood within the third degree. Second degree is sibling, third degree and uncle. The child's step-parent, keeping in mind the best interest of the child. What happens from a procedural standpoint, and there was one exam where the procedural question came in, is that the person seeking to be named tutor of the child files a petition for tutorship, and they have to name all of the people who qualify as these relatives. And then they have to give notice of the suit to all these relatives who can then come in and seek to be named as the tutor. And so if there's an opposition to uncle being named as tutor by sibling, they come in, the court has a hearing and determines what's in the best interest of the child. But all of these people need to be notified. There's a notification requirement. So the last type of tutorship is called the dative tutorship. And when there is no tutor by will and the child has no listed relations by the effect of law, then the court appoints a tutor. I mean, this could be someone who's not one of the listed relations, or it could be a person who's been caring for the child if the child has no relatives. There is something called a provisional tutor, and the court can come in and appoint a provisional tutor pending the appointment of a particular tutor. And they can also divide that provisional tutorship over the person of the minor and the property of the minor. Tutorship, natural tutorship, will take place as of right. Like immediately upon the death of dad, mom will become the natural tutor. Mom has to qualify for the office as provided by law, and that is, for natural tutorship, usually parents do nothing. But once they want to sell a piece of property, then they will come in and have to get qualified by the court. Qualification is, this is what's really confusing about this area of law. You see, I have qualifications. That's different than qualifying for the office. Okay, you have to be a certain type of person to even be a tutor, but in order to qualify and perform acts as a tutor, you have to, go to letter D, take an oath, post security, and get letters of tutorship. So it's a little confusing because the word is used in two different contexts. So when I say the natural tutor must qualify for the office as provided by law, they have to come in when they want to sell a piece of the minor's property. They have to take an oath, I swear, and you have to sign a document. You have to post security, and then you get these letters of tutorship. For every other type of tutorship, tutorship by will, by the effect of law, or dative tutorship, the court must confirm the person as tutor. They have to actually have a confirmation hearing, this person is confirmed, and then that person must qualify. Now, the qualifications, as distinct from qualifying for the office, is that all tutors have to be majors, not interdicted or incompetent, not a felon, indebted, or an adverse party, Or, don't you love this one, of bad moral character. That would eliminate some people, but that never comes up, right? Because most parties are coming in, fighting for tutorship from different sides of the family, and I've never heard this one brought up before. Parents cannot be excused from the obligations of tutorship, but a lot of other people can, and they're listed there. So when I talk about this qualification, what the tutor does is they come in and they take an oath of office. It's on a pleading paper. It says oath, and they have to sign it saying they're going to act in the best interest of the minor. Most tutors must furnish security. They have to post a bond or some type of cash, and natural tutors don't have to post security, but ultimately what happens to natural tutors is there's a legal mortgage that gets placed on their property, but they don't have to come up with any money or any bond like the other tutors. And then the clerk of court issues letters of tutorship. It's on a pleading paper. It says letters of tutorship. This gives authority. Then they can go to the bank and use this to enroll the kid in school, to go to the bank and withdraw money. The letters of tutorship are very powerful. A natural tutor, without coming in to qualify and taking the oath and the legal mortgage and all that, may perform any act affecting the minor which involves less than $10,000. This provision gets used all the time. Most people who use the tutorship articles are personal injury lawyers, because if you're going to settle a case for a minor under $10,000, you don't have to do anything. But for so many settlements, it's over $10,000, you actually have to appoint a tutor, and so you have to go through a petition to appoint a tutor, and then the court has to approve the settlement with the minor. So this really, while it sounds like it's a family law issue, you might be surprised to learn that most family lawyers aren't doing it. It's more personal injury lawyers that are doing it, because it's usually when the minor comes into some property. What are the duties of the tutor? You see, it's custody of and care for the person of the minor. Okay, which is odd because that sounds more like custody, but it's included in tutorship. They have a fiduciary duty to the tutee, and liability will prescribe 4 years after the age of majority. The rights of the tutor include the right to bring lawsuits, defend lawsuits, buy or sell property, and accept donations. The tutor has to file an annual accounting. From a practical standpoint, that is not happening, but they're supposed to do an annual accounting of all the property of the minor. When does tutorship terminate? Obviously, on majority, tutorship will end, or emancipation. Emancipation will end the tutorship relationship. There is something called continuing tutorship. That's what B is all about. This is for a mentally incapacitated child. You can be put under a permanent state of tutorship. Okay, and that is continuing tutorship where that major remains a minor. Your other option besides continuing tutorship is interdiction, which we're going to talk about in a second. But mentally retarded children can be placed under continuing tutorship where there is always someone over their affairs. The under-tutor. In every tutorship, there is an under-tutor. The under-tutor is like the watchdog to make sure that the tutor is doing things appropriately. The under-tutor must perform any acts that the tutor fails to perform, but ultimately, if the tutor dies, the under-tutor does not step in. The under-tutor has an obligation to alert the court, and then another tutor is appointed. Okay, that's the law for tutorship in a nutshell. You're going to see some of the law of tutorship in the Code of Civil Procedure. One of the problems with tutorship is that half of the law, and I think it was substantive, was in the Code of Civil Procedure. Half of it was in the Civil Code. So you're going to have to pull it together from the Code of Civil Procedure. I simply don't have enough time to put all that in the outline as well. And you can see the question that was asked, which focused more on the Civil Code with the exception of that notice requirement. I think because there's 4 different types, you could probably get some good multiple choice questions out of this, but this is not a hard area of law, and you might want to pay attention just in case some procedural questions kind of creep in as well. Okay, emancipation. Emancipation is an area that has only come up, in my knowledge, once on the bar exam, and it was actually in a true-false question when they were asking true-false questions about the different types of emancipation. And certainly you need to know when a child is emancipated, their rights to get child support end. I could see that issue being tested. This law used to be a lot more meaningful when the age of majority was 21. But to emancipate a child, you really only do it when the child is 16 or 17. So it's a very short window to emancipate a child, so most people just don't use it. The law was amended in 2009, and now there are 3 types of emancipation. The true-false question said there are 3 types of emancipation, and one of them was incorrect. So it was a very simple question. Multiple choice might kind of do the same for you to see if you know there are 3 types and maybe what the differences are between the 3 of them. There is judicial emancipation, emancipation by marriage, and limited emancipation by authentic act. Make sure you know those 3. For judicial emancipation, it's exactly as it sounds. You have to go to court. Judicial emancipation. A court can order the full or limited emancipation of a minor aged 16 years or older. So we're talking 16 and 17 is when this would apply. You've got to be 16 years or older, and it can order full emancipation, converts the minor to a major, or limited emancipation, gives the minor some rights as a major. And the standard is, the catch-all, good cause, right? Use good cause again. What is the meaning of good cause? Well, the comments give you some examples, but it could be for a variety of reasons. Good cause may exist when the minor's parents need to be protected from liability for the acts of the minor. This is when it's used most often. So you have a child who's 17, who's not living at home anymore. Now, of course, they have to remain home and obey their parents, but the parents can't do anything about it. You talk to most police officers, a lot of regulations won't even allow the police to go pick up a 17-year-old kid. And so 17, he's living elsewhere, doing dangerous type of behaviors, and if he hits somebody in the car while he's high, mom is going to get sued because she's vicariously liable for his acts. So mom comes to you and says, I'm really scared. In fact, this exact thing happened. My mom came to me and she said, my son stole my car. I don't want to call the cops and have him put into jail, but if he kills somebody in that car, am I going to be liable? Yes. You need to emancipate him. Now, you're going to have to go to court to have him emancipated, and there are mixed feelings about whether the child should be emancipated at all if the parent can't control them. But that's what I think judicial emancipation would be used for. You used to be able to emancipate a child to relieve yourself from liability by an authentic act. That was pretty unfair because everybody who knew or was a lawyer signed an authentic act of emancipation for their child when they turned 16 and put it in the drawer. Never told their kid anything, and then when they got sued, they presented the document. And that's, ingenious lawyering. And when this was revised, there was some concern, obviously, that this wasn't uniform across the board. It wasn't very fair. And so now, if you want to protect yourself from liability, you've got to go to court, and that's one of the reasons. If the minor needs capacity to enter contracts, minor's writing some cool program for a video game, and the company he's writing it for is concerned about contracting with a minor, he can be emancipated. Minors can also seek to have themselves emancipated when they're being treated poorly. What happens for the judicial emancipation? The minor, who is 16 or older, or the parents can individually file or they can jointly file. But they go to court, file a petition for emancipation. When the court signs the judgment of emancipation, that's the day the minor is emancipated. It can be modified or terminated by the court for good cause. And actually, for a judicial emancipation, the minor could be returned to a state of minority. Never seen that happen, but it could happen. If the minor's not acting appropriately, could be returned. That's judicial emancipation. Emancipation happens by marriage. Full emancipation when a minor gets married. Even if they get married and divorced between 16 and 17, they're still considered emancipated. The last type of emancipation is limited emancipation by authentic act. You do not have to go to court for this one. The minor and the parents or the tutor can execute an authentic act of limited emancipation. Again, for every one of these, it's 16 years of age or older. The act gives the minor capacity to make juridical acts stated in the act of limited emancipation. Other than that, all effects of minority continue. So if the kid was going to write video game programs for a company, you don't have to go to court. Now, why would you go to court? Because the company wants you to do that and actually have a judgment of emancipation. They don't trust the authentic act. A lot of these, it's because what the litigants want, not what is absolutely necessary. You don't have to go to court. You can sign an authentic act of emancipation, give the child the authority. It's a heck of a lot cheaper than filing a lawsuit, and then the minor can execute this juridical act. It's effective when the act is executed, and it can be modified by an authentic act as well. You could also go to court and have it modified for good cause. The authentic act of limited emancipation is very clear now that it cannot relieve the parents of liability for acts of the minor child. The only way to do that is through the judicial emancipation. So that's emancipation, not hard. I think good multiple choice material. All right, interdiction. Incompetent persons in interdiction has been tested 5 times in the past 24 exams. It was tested really from 06 to 09 often. And it hasn't been tested a lot recently. I think this could also be good for multiple choice questions because there's not too much here. You should make sure you take a look back that far to the old exams because the questions were really repeat questions. And so if they think, oh, we haven't asked one of these discrete topics, I suspect they would pull from one of those old questions. So make sure you use those. There are 2 types of interdiction in Louisiana: full interdiction and limited interdiction. Full interdiction, you need to make sure you know the test, because if you get an essay question, this is what they're going to want you to say. A person can be interdicted if, due to an infirmity, so you need to use that word infirmity, is unable consistently to make reasoned decisions regarding the care of his person and property. Circle that word "and," because that's the big distinction between full interdiction and limited interdiction. Or to communicate those decisions. So let's say you can make them, but you're unable to speak. You can't communicate those decisions. And whose interests cannot be protected by less restrictive means. What does that mean? That means, can we use a limited interdiction? That's less restrictive. Can we use a power of attorney? That's less restrictive. Can we just control this person's assets without taking away all of their capacity by just operating under a power of attorney? That's why you recommend to your clients, while they are able to make reasoned decisions, to sign power of attorneys, because that's the person who will govern their affairs. Because you're having a curator appointed over a person who makes all decisions for them. And so this interdiction, full interdiction, is considered a civil death. You have no capacity to make any juridical act. You cannot make a will. You cannot do anything. And so it's a very serious process. It's hard to get a full interdiction. Full interdictions are people who are in a vegetative state and can't take care of themselves at all, their person. People who are mentally unstable can be fully interdicted because they can't make reasoned decisions over themselves or their property, but it takes full capacity away from them. And interdiction applies to majors. Okay, now we're in the realm of majors. Tutorship, emancipation, minors. Interdicts, absent persons, we're going to talk about majors. And so we're the age of majority. The second type is a limited interdiction. It strips you of some capacity. But if you see under letter A, the defendant must be incapable of caring for his person or managing his estate, not both. Both is full interdiction. Can't take care of yourself or your property. Limited interdiction is the same test. So it's due to an infirmity, is unable consistently, that whole test, you would cite that again, but you're talking about one or the other, or any aspects of either. And so in a judgment of limited interdiction, you take away whatever rights they can't control. It's very specific as to whatever their ailment is. Maybe grandmother can still live by herself, but she's now starting to give money away to people who call her on the telephone. and say, I'm a televangelist, you remember me, right? Oh yes, will you write me a check for $10,000? That happens. You might get a limited interdiction over her property, but not over her person, because she can still decide if she wants to live on her own. That's what a limited interdiction is about. When a petition for interdiction is pending, the court can order a temporary or preliminary interdiction when there is a substantial likelihood that the grounds for interdiction exist and substantial harm to the health, safety, or property is imminent. So you're really doing it without having your full hearing. But when you can make these showing, you can get a preliminary or temporary interdiction. So what's happening is usually it's a person who cares for now someone who can't take care of themselves, and they're filing a petition for interdiction to be named curator. So they want to be curator over that person's property and or person. So the court ultimately appoints a curator to represent the interdict and to care for the person of the interdict. The interdict has a duty of care and loyalty over the interdict and must act in the best interest of the interdict. And then for a limited curator over a limited interdict, it's only the powers granted to them in the judgment. Just like in tutorship, there is an under-curator. It's a watchdog that watch what the curator is doing. But unlike tutorship, neither a curator or an under-curator is personally responsible for the torts of the interdict. Tutors are personally responsible for the torts of the minor. Parents are vicariously liable for the acts of the minor. But the same is not true for curators of an interdict. It used to be, but nobody would be a curator over the interdict. And it's not a minor. We're talking about a major who sometimes you can't control. So they can be responsible for acts of bad faith, but they can't be vicariously liable for the tortious acts of the interdict. So here are the effects of interdiction. Full interdiction, civil death, lacks capacity to make juridical acts. Limited, lacks capacity to make juridical acts pertaining to the property or care that's in the judgment. So for limited interdicts, for donations, and you'll see this in Code 2 as well. For donations for a limited interdict, let's say you interdict all of their liquid property. Like not their real estate where they'd have to go to a lawyer to transfer it, but all of their accounts. And now they can't write checks on any of their accounts anymore. So now the interdict cannot donate that property during life, but there is only a presumption that they can't make a will for that property. Because a full interdict can't make a will. I mean, that's pretty serious. They can't even make a will. Where a limited interdict, it's presumed you can't make a will over the property subject to the interdict, but it could be rebutted. So limited interdicts can make wills. You might have to overcome a presumption for part of that will, but they can still make a will, unlike the full interdict. Any juridical act made prior to the effective date of interdiction is not affected. Obviously, if you see that, you might talk about challenges for capacity. Sometimes there's capacity issues before you get interdicted. But you can't, deny any juridical act if the interdiction is not complete. Can you modify and terminate an interdiction? Yes, for good cause. This was asked in part of the question. You can modify or terminate a judgment of interdiction for good cause, and of course it will terminate at the death of the interdict or a court judgment terminating it. You can seek to have a curator or an under-curator removed. Okay, the specific question that you need to make sure you take a look at was a parent who was actually the curator over a major child who was in a very bad accident. And the parent did not buy a wheelchair that would have helped the person get around, the child get around a lot easier, and was taking vacations, and then the other parent came over, and the adult child, had some bed sores. So there was concern that she wasn't, turning the child or having good care for the child. So can you have the curator removed? And of course, you know instinctively that of course, yes. Any interested person, it could be spouse, relative, or interested person, can petition for removal, by showing they're not performing their duties. The standard is, are they acting in the best interest of the interdict? There's a whole host of factors. These are very obvious. If you're mismanaging your duties, if you're failing to give independence to the interdict, if you fail to obey an order of the court, would all be reasons to have that curator removed. Here's a few blurbs about preliminary and temporary interdictions. Preliminary interdictions happen after an adversarial hearing, and they last a little bit longer. This occurs in other areas of the law, too. If it's a temporary thing, it's ex parte. Temporary restraining orders, those are ex parte. Preliminary injunctions, those are after adversarial hearings. Same thing here. Temporary interdiction, ex parte, only lasts for 10 days. Preliminary interdiction, adversarial hearing, lasts for 30 days. And then you get to the permanent level after you've had a full trial to determine interdiction. There is a specific provision about the wrongful filing of an interdiction petition. This has come up because what was happening, and this is relatively recent, is that older man marries younger woman and starts to give all of his property to younger woman. Children who are angry about this say, Dad can't give away our inheritance, and so therefore we're going to have him interdicted and take control of his property so he can't give it to stepmom who's younger than us. And if, you can see now, this became such a problem that there was a law passed that if the petitioner knew or should have known that any material factual allegation was incorrect and false, then they can be liable for damages for the wrongful filing of the interdiction. You'll see the procedure in your procedure outline as well for interdiction. There was really in the question, there was no procedure that infiltrated that interdiction question, so make sure you take a look at that. All right, our last topic, woohoo, is absent persons. Absent persons was tested for the first time in 2011, and it was really just 2 questions. It was used in a property question, but someone was absent, had been missing for a long period of time, and then there was some property questions about what to do with the property. So you had to talk about the absent persons area of the law. Okay, so the absent persons area of the law, most of the cases in this area are very, very old, when it was hard to find people. Now it's pretty easy to find people. People don't go absent where you can never locate them, but that's what the law of absent persons deals with. It's a person who you don't know is dead or alive. They're absent. They're gone. And now, and actually it came up after Katrina. I thought maybe we'd see some resurgence of this, but in the case law we certainly haven't. The house sitting next to you is still vacant, and the property owner, you're not sure if they're dead or alive, and now it's overcome with weeds. You want to buy the piece of property. You can't find out anything about this person. You could seek to have a curator appointed over the absent person to deal with the property. Okay, that's really what this is about, to deal with the property of the absent person while they're gone. They have the right when they reappear to get their property back, which is what happened in the bar exam question. The person reappears, and what type of property do they get back? So here's the definition. An absent person, and when you get to procedure, there are absentees under procedural law. That is not the same definition as an absent person. So don't let that confuse you. An absent person is unique under civil code, under the first civil code test. It's different than an absentee that needs to get served. Okay, so some people tend to confuse that. An absent person is one who has no representative in the state and cannot be located with diligent effort. So the cases have said you need to make an effort to find this person. You have to, probably now you'd have to sign up with one of those people finder things to try to find them, maybe post an ad in the newspaper where they were last known to be living. And if you still can't find them, then you can go to court and you're going to say this person owns property in Louisiana and it is necessary that a curator is appointed for whatever the reason is. So you're going to have to show that they own property in Louisiana, that it's a necessity, and that you tried to find them. and they cannot be located. So then a curator, which is different than the curator over the interdict, but again, this is like a person who is over someone else's property, is appointed. What is the effect of the appointment? Well, unlike interdiction, the appointment of a curator over an absent person does not deprive the absent person of the capacity to make juridical acts. However, the disposal of immovables is subject to the public records doctrine. So if you have an absent person and a curator has been appointed over them, the curator has the authority to sell the absent person's property. The absent person has authority to sell their property as well. But if the absent person sells a piece of immovable property and fails to record it, and then the curator sells the absent person's property, the person who the curator sold the absent person's property is going to prevail, unless the absent person recorded their sale in the records of where the immovable property is located. And once you think that happens, you'd be able to find them. I mean, it would probably that the curatorship would end because the absent person has been located, because now they're filing papers in the jurisdiction. What are the powers of the curator? Administer and dispose of property. You can sell property. When the absent person is a spouse in community, then it is only over the spouse's separate property. You can get it over the community property if they have an exclusive right, but we're generally talking only over the spouse's separate property because either spouse in a community has full rights to manage community property. What are the duties of a curator? They must file an accounting. They have to give notice of termination of the curatorship by filing this notice in the court file. And then, if the absent person is presumed dead, then the curator has to initiate a proceeding to declare them dead. And you'll see this, there's a big distinction in the law between being presumed dead and being declared dead. I'm going to talk about that in just a second. When does a curatorship terminate? When the absentee appoints a representative to represent his interests. The representative does not have to be in the state of Louisiana. The representative could be in any other state, but they have to have authorization to act on behalf of the absent person in the state of Louisiana. It also terminates when the absentee is located or reappears. That's what happened in the bar exam question. The reappearance doesn't have to be in Louisiana. They just have to know that they're alive now. And it also terminates when the absent person dies or when there is a judgment declaring their death. Because remember, we talked about death under the law happens in two ways: doctor certification and judicial declaration. You had the Article 30 declaration when death seems certain. This is the Article 54 declaration, when after the passage of time, you can get a declaration of death that actually arbitrarily sets a date of death for a person. There's no doubt about it. So here's how it works. If the absentee is absent for 5 years, he is presumed dead. That is a legal term of art. Presumed dead in the context of the absent person has legal significance because you can't be a successor after you're presumed dead, even if you're not declared dead yet. The interested person, which often will be the curator, can petition the court for a declaration of death, which is different than the presumption, and a determination of the date of death. What most courts have done in these cases is declared their death 5 years from the date they were last heard from, arbitrarily. There is a provision that was around for Katrina and Rita, but I don't think that would operate any longer. And then the judgment can be amended if there is clear and convincing evidence that the date fixed was wrong. Can you imagine that? I mean, I have never seen that happen. But let's say you arbitrarily choose this 5-year date, and then you find out they actually died 3 years before. You've already distributed property to the successors, and there was a child alive then that could take, but 3 years when he actually died, the child was not even alive, not even in utero. What do you do with that? Do you get the property back? It could be crazy town. But we haven't seen that happen, but know that you could amend the date of death, the judicial declaration of death. Obviously, this matters. It matters for succession purposes. It matters for life insurance proceeds. I mean, it matters. And the succession is opened as of this arbitrary date of death. Now, number 3 is important. A person who is presumed dead, and remember, you're presumed dead after 5 years, or declared dead, that's when you get that judicial declaration of death, at a time when a succession would have opened in his favor, cannot be a successor. Act as if he predeceased. So even though you don't have a declaration of death yet, and the person is just presumed dead, you treat them as though they have predeceased. And you'll see, if they would have had inheritance, they can come back and get it, but in the condition that it is when they arrive back. And that's really what this last section is about, the reappearance of the absentee. If the person who is declared dead reappears, okay, so what happens is the curator is managing his property, right, for 5 years. Might be paying taxes on a house he owes because there was some accounts that were still out there, is having the grass cut, managing all the property. After the person has been absent for 5 years, that you can then declare him dead, you'll be able to transfer that property to whoever the successor of the absent person was. But if he reappears, he can recover his property that still exists, maybe that house, in the condition from his successors or their transferees by gratuitous title. You're not going to get it from an onerous title transferee because they paid for it. But if it's their successor who has the house, they can come get that house back in the condition that it exists when they reappear. If the property was alienated, they can get the net proceeds. If the property was encumbered, they can get the diminution in value. Now, what about this inheritance? Like, you were supposed to get inheritance, but remember, you're now act as though you predeceased. So if the person who was presumed dead or declared dead reappears, he can even get his inheritance back from the other people who took what would have been his inheritance from the successors or the transferees by gratuitous title. Again, can get the proceeds, collect for diminution in value. The absent person who reappears is treated like an omitted heir in a succession, and you're going to hear this from Code 2. And this is a big deal. A lot of people don't know about this. If the absent person reappears within 2 years of the date of the final judgment of possession, he can demand even immovable property from transferees by onerous title if they received it from an heir through a judgment of possession. Okay, this is important because if you're handling the sale of property that's in a succession, you want to make sure that there's no issue of absent person. If there is, you're at risk for 2 years. Really, in any succession, you're at risk for 2 years if there's an omitted heir. And so if you're going to purchase from an heir through a judgment of possession, for that 2-year period, you'll get your money back, but you might actually have to give the property back, which is unusual because Louisiana law, for the most part, protects onerous purchasers of property, right? If the absent person reappears and acquires either his property or his inheritance, he can't get the fruits. That seems unfair because they're considered to be good faith possessors. And they can also keep any improvements on the immovable property. They're treated like a good faith possessor because they had no idea the person was going to show up. All right, you guys. I am finished with Code 1. Good luck. Good luck on the rest of this process. If you have any questions about Code 1, please don't hesitate to contact me, and good luck.